ನೀವು ಸ್ವಲ್ಪ ಮಂಜಿ ಬೆಳಿಗ್ಗೆ
ಅಂತ ಹೇಳ್ತೀನಿ. ಆಮೇಲೆ ನಾನು ಅಪ್ಲೈ ಮಾಡೋದು.
ಪಾಸ್ವರ್ಡ್ ಗೊತ್ತಿಲ್ಲ ಅದು ಪಾಸ್ವರ್ಡ್.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. ದಯವಿಟ್ಟು ಏನಿದೆ
You can file application for madam, application for vacating stay. It's not valid. Officer.
ನಾ 5 ನಿಮಿಷ ಆಗತ್ತ. ಒಂದು ಎಷ್ಟು ಮಾಡಿದೆ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ಬೋದಾ? ಬರ್ತದೆ.
Sorry, we took more time in this matter. Nandakishore. Firstly, I should thank all of you to teach me much of land acquisition law, which much exposure I did not have otherwise. Okay, and I have considered all contentions. Petitions dismissed.
Both the petitions.
Yes, the challenge to acquisition in both the petition fails, and acquisition is held to be valid and effective. Petitioner shall be paid the compensation to the subject lands at the rates agreed to in the meeting held on 24/9/99, forthwith by accomplishing the acquisition proceedings in accordance with law. Keeping in view a spate of petitions and the time spent in prosecuting them, and also the skyrocketing of real estate prices, I direct the official response to pay to the petitioner interest at the rate of 12% per annum, in addition to what is payable under the provisions of the 1894 Act from the date of the award within 3 months. If delay is proved in making the payment, petitioner shall be entitled to 1% additional interest per mensum, and on payment, the same shall be recovered from the officials responsible for causing delay and in accordance with it.
Make a request. Interim order of status quo that was granted could be extended for another period of 3 weeks or 4 weeks, ma'am.
First, third, on the, after the pronouncement of the judgment, learned counsel, Professor P.N. Rajeshwar, appearing for the petitioner on record, made a request for continuing status quo order made by this court during the pendency of these petitions, so that he can explore the possibility of a further challenge to the same. First, years have rolled since the acquisition was initiated. First, by granting 4 weeks, no prejudice would be caused to anyone. First, denying such a request would be prejudicial to the interest of petitioner. First, next one, in the above circumstances, status quo, as was ordered by this court, Detidia,
I don't have the data.
would continue for a period of 4 weeks. 4 weeks, and expires on the efflux of time.
Your Lordship, could you please record our objections, Your Lordship? Respondent number 4, objections to that submission.
Well, you know, after making the order, you are objecting anyway.
I didn't want to interrupt Your Lordship.
This was objected to by the
Respondent number 4, APMC.
by the panel counsel appearing for the APMC. First, there is no merit in the objection. Yes.
Grateful.
Much obliged.
Sorry, I took more time
That's okay.
because of my slow nature of working and
Definitely we are
little
sure that
pressure of
yeah,
pressure of
masterpiece,
work.
ma'am.
That's bala ಬೇರೆ matters ಎಲ್ಲ ಇತ್ತು. But every point I have covered.
Yes.
Only one point which I have said is, in the light of Justice Bopanna's judgment,
Yes.
proposition I agree,
Yes.
but its invocation I did not agree, because the right to compensation, V.G. Ramachandran says, always subject to vouching the title to the land.
Yes.
But section 66 proceedings were pending. Therefore,
Yes.
and 66 touch the title to the land itself.
Yes.
That's the reason I have said.
Yes.
I may be wrong also.
Yes. My lord, one submission. ಸಾಕಲ್ಲ? ಮುಗಿಸ್ಲಿ.
Yes.
My lord, it's a matter pertaining to KLGP.
Ah.
The petitioner has been accused by has been narrated as a accused.
When do you want?
Tomorrow, my lord.
Tomorrow?
Because the
ಏನ್
matter
urgency?
is coming up before the special court day after tomorrow. And the
Tomorrow.
petitioner is 83
Come on.
years old. Much
My
obliged.
lordship, writ petition number 566 and 808.
Ah.
These two writ petitions arise out of the arbitral proceedings, my lordship, on the orders of an IA. The arbitration mandate is going to expire this month only. My lordship. That's the urgency. It may be listed tomorrow. My lordship.
When do you want?
Tomorrow, my lordship.
This month ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಯಾವತ್ತಿದೆ?
Arbitral proceedings is going to be expired this month only.
This month.
This month only.
Next week. ಕರೆಯೋಣ.
My lordship, this orders on IAs only, my lordship.
Correct. ಅದಕ್ಕೆ.
So
Next
tomorrow, my lordship. Tomorrow.
Next week. Yes.
My lord, serial number 38, my lords.
38.
Yes, my lords.
Ah.
My lords, 2 weeks time, my lords. Criminal appeals have been preferred by the prosecution on the same factual grounds, my lords.
Yeah, KLGP. KLGP.
Yes, my lords.
2 weeks at the request of.
This matter may be taken tomorrow, pre-deposit about the DRT order.
ಯಾವತ್ತಾಗಿತ್ತು ಆರ್ಡರ್?
6th is going to expire.
When the order was made?
9/1.
9/1.
9/1. 6th is going to expire.
Day after. 6th 9/1 ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಇಷ್ಟು ದಿವಸ?
Ready ಮಾಡ್ಬೇಕಾಯ್ತು, ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಸಿಗ್ಬೇಕಾಯ್ತು ಅಲ್ಲಿ.
Sorry.
DRT ಲಿ.
ನಾಳೆ.
ನಾಳೆ ಮೇಲ್. Tomorrow ಮೇಲ್.
Okay.
My lord, serial number 18, my lord.
18.
18, ITA. I request a short adjournment, my lord. My senior is unwell.
Not well.
Yes.
All. 2 weeks.
Yeah, 2 weeks.
2 weeks.
My lord,
At the
serial number
request of.
5.
Huh?
Serial number 5, my lord.
Five.
5. I appear for the appellants.
Ah.
A learned ASG is appearing in the matter. There is some difficulty today, my lord.
There is difficulty.
Yes, my
23 matter.
Your lordship?
All right. 2023 matter.
Your lordship may have it on 17th or 18th, my lord, if it's.
ನೋಡಿ 17th 18th ಹಾಕಬಹುದಾ?
My lord, I'm for the respondent in this case. Any Mondays can be, because
Monday is
the
convenient
advocate
to
has to come from Delhi, my lord.
Is it?
Yes, my lord.
Your ASG is from Bangalore.
Yes, my lord.
Then we'll give Monday, some Monday.
Any Mondays, my lord.
I was informed 17 and 18th would be convenient.
We have
for
to
learned
accommodate
ASG.
a foreign advocate. Yes.
Monday, which date, sir?
17th. All right, 17th.
Much obliged.
This date is chosen consensually by both the sides, and therefore further request for further adjournment will not be entertained. Yes.
Much obliged.
21. 28, your lordship. I appear for the respondent in serial number 28. I have requested for details, my lords, kindly 2 weeks time will be granted.
28 ನಲ್ಲಿ
28, my lords.
ಏನ್ ಡೀಟೇಲ್ಸ್ ಇದು?
Ada, I have checked,
ಕರೆಕ್ಟ್. ಕರೀರಿ, ತೊಳಿ. 2 weeks at the request of Raghu,
please, my lords.
26.
finally. 26,
And 30. Narayana has agreed. Could it be taken up next Monday, 10th February?
next Monday. Next Monday ಎಂತ ಇದೆಯಾ? ಹೋಗೋದಾ? All right. Call next Monday at the request of.
My lord.
So,
Serial number 21.
20,
21, my lords, 21.
21.
We are taking some orders from assessment officer, my lords. We have 2 weeks, my lords.
All right, 2 weeks at the request of. Yes. ಅವ್ರಿಗೆ ತಿಳಿಸ್ಬಿಡಿ, ವಾಣಿ ಮೇಡಮ್.
Yes, madam.
Yes.
Serial number 2, your lordship.
Serial number 2. Generally,
Yes.
5 up to 1 to 5 are not mentioned. Anyway, you are mentioning it 2.
Your lordship, we have filed the synopsis, but still it is showing as an objection, your lordship. Can it be posted after 2 weeks? We will file it again.
Alone. Filing of synopsis dispensed it. Call after 2. Why 2 weeks? 2018 matter. We'll dispense it, argue the matter. We have read the papers.
Your lordship, I'm just a proxy advocate, your lordship.
All right, 2 weeks at the request of finally.
My lords kindly.
Ah,
My lords,
Mr.
review
Vice Chair.
petition in a.
party ಏನೋ ಇದ್ದಾರೆ. ಏನು?
Sir, my lord, this court had fixed January 7th last month as the hearing date for this recall petition, but they could not trace the file in time. So it was not listed last month.
Now traced.
Now they have traced it, sir.
Correct.
So
ಯಾವ
next
date ಬೇಕು?
next week, Monday,
Monday ಬೇಕಾ?
Monday. Please, Monday.
Monday ಭಾಳ. Monday ತುಂಬಾ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇರ್ತದೆ, ರೀಚ್ ಆಗ್ಲಿದ್ರೆ ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ನೀವು?
Sir, I'm in Bangalore only. sir.
ಬೆಂಗಳೂರು?
Yeah. Tuesday.
Next week.
Tuesday, sir.
Huh?
Monday,
Tuesday, Wednesday.
Monday, sir.
No, Monday. Yes.
12th, sir. Okay, thank you.
Okay. Next.
Serial number 27, my lords.
Yes.
My lords, appearing for the appellant in this matter, I kindly pray for 2 weeks' time, my lords.
2 weeks you want. 27.
20, serial number 27, my lords. CEA 10.
3 matter. All right. Akash Shetty.
Yes, my lords.
All right, 2 weeks at the request of Mr. Shetty.
Obliged, my lords.
Yes, Aditya.
Lords, review petition, my lords, on the question of whether ethyl alcohol is within the schedule for entry tax. A scientific question, praying for review, otherwise there will be loss to revenue and risk of contempt being filed. Fresh filing, my lord, not yet been listed before this one.
Review means original review, na?
Yes.
Original review. Okay. Not yet decided by this court. On the review petition, na?
Review petition.
Okay. But it's more like revision, na?
Matters.
Third. Yavat bekidu.
6th, man.
All.
If possible, at your lordship's convenience.
Alla, yavattu. Contempt yavattu.
Contempt or haktare, hakilla, at your lordship's convenience.
Next week, account.
All next week.
Serial number 32, my lords. May seek for 2 weeks accommodation, my lords.
32?
32, my lords. It is for admission, my lord.
Welcome, but will read, na? All right. 2 weeks.
Grateful, my lords. Grateful, my lords.
Come to Mike. Serial number?
Serial number 44, my lords.
44.
Matter is listed under the head final hearing, but matter is not admitted. In fact, the cause list itself notes that the appeal is not admitted.
But the admission is post post hearing at the post this matter for admission. Come on. The hearing stage having not yet reached. Okay.
Serial number 36.
Ah.
Serial number 36, my lords. I'm appearing for the appellant, my lords. May I request a week's time, my lords?
36.
Please, my lords.
2016 matter.
Please, my lords. There is some inconvenience for the arguing counsel, my lords.
Inconvenience. All right. Next week, Madi.
Please, my lords.
All right. Next week, finally.
Much obliged.
At the request of Anupama.
Please, my lords.
Yes.
Lordships. Your lordship, in serial number 41, your lordships. Your lordship, I'm seeking for a short adjournment, your lordships.
41. 2018 matter. What is there in this matter?
Your lordship, serial number 43, your lordships. I'm extremely sorry, your lordships.
43.
Yes, your lordships.
All right. You are Balram.
Yes, Balram says junior, your lordship.
So Balram is making prayer to Krishna. Anyway, all right. Krishna and other brother also. 2 weeks at the request of. We are agreeing with your contentions because of 9-3. 9-3, then another judgment of apex court also. We are holding, whenever there is failure of the first highest bidder does not come, then the only alternative is to go for again one more auction only. Yes. We have followed Orissa judgment. Orissa judgment is a very beautifully written judgment, the best and way. And we have incidentally considered whatever points Mr. Dhan had argued, those points also we have considered. Okay. But there is something which we will read this. Writ is allowed, writ petition is allowed, writ of certiorari issues quashing the impugned orders of the DRAT Chennai and DRT2 Bangalore. Petitioner shall pay rupees 6 crore only under the OTS arrangement with 18% interest on the delayed payment of this sum within 4 weeks, and third respondent shall accept the said payment towards fruition of the subject OTS arrangement. Petitioner shall pay rupees 1 crore only to respondent numbers 1 and 2 collectively within 3 weeks, failing which the petition shall be treated as having been dismissed. And as a consequence, the order of the DRAT would be given effect to forthwith.
One small indulgence.
Nothing like that.
Lord, one small indulgence.
Lord, some 45 days time may be given.
Lord, I appear for the respondents. My lord, may I please make the request?
Respondent number 3. Let them release my mortgage document upon the receipt of that 6 crores.
Yes, this we have said, that is for that purpose only. Okay. We do not know if
Lord, we want some more time, you know.
No time.
First petitioner.
No, nothing like that. Yes.
My lord, I appear for the respondents. My lord, there was an order of status quo. My lord, they want to explore a further challenge.
My lord, the time for payment of 6 crores.
Already.
The time for payment of 6 crores.
That's we have said that. A learned counsel appearing for the respondent
One and
buyer
two.
of the subject property seeks a period of 4 weeks for exploring the possibility of challenge to this order. First off, granting such a short reprieve would not prejudice anyone. First off, in view of the above, this order is kept in abeyance for a period of 4 weeks only. And on the efflux of time, it withers away in thin air. Yes.
Deeply attached.
Next.
See the copies, my lord.
That's
Was
2018
required
matter.
to file an affidavit. I sent it for waiting to Central Railways, my lord. Now it's
Summarize
Monday, my lord.
what it is. 2000.
Some time. Generally,
Clear,
Raghu will not oppose a request for a
I'm
time.
not opposing that.
Ah.
Some of the orders, objections may have to be overruled, my lords. And I just give
My lord,
the,
yeah, copies are received, my lord. So after
ಯಾವ್ಯಾವ
that-
ಏನೇನು overlook ಮಾಡ್ಬೇಕು?
the issue, my lords, is.
Which are the objections you want to be overlooked? Just tell them, we'll overlook.
1, 2, and 3, my
Huh?
lords. 1, 2, 3, my lords.
Bakadi. On hearing learned senior advocate, Mr. Raghu, the objection, office objections at 1, 2, and 3 are rendered infructuous. Okay.
This is a 2018 matter, my lords. It has already been admitted. Lordships could post it for early disposal. Very
Final
short
hearing.
point, my lords, similar issue. The railways has to reimburse the service tax, which was imposed after the contract came into being.
Similarly, one which we
Somewhat
decided
similar.
more or less similar.
Somewhat similar.
Share that copy of the judgment.
It's yet to be released.
Not yet released.
Friday, my lords. We choose it.
Correct. But we sign and go. ಯಾಕೆ release ಆಗಿಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿ.
Well, operative portion, your lordships announced.
No. We have.
I'm sorry, my lord.
Yes, we
check
have
it out.
completed. We don't go home till we sign last of the
check it out.
judgments, barring
We'll
a
check.
few where complicated issues are argued.
I'll have it checked.
Just
I'll have it.
call this next week. We can call week after next. We'll call this
My-
next week or week after next.
17th, my lords.
Huh?
17th.
No date.
Tax
We do
day.
not know.
Tax
Let us
day,
see.
my lords. Tax day.
Tax day, but there are other matters also.
My lords.
Week after next, we'll do that. Okay.
Deeply
At the request of Soins.
Obliged.
Deeply obliged.
Yes.
ಸ್ವಾಮಿ ಅದು ಅಬ್ಜೆಕ್ಷನ್ ನೋಟಿಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಅದೆಲ್ಲ ಮಾಡಿದ್ದು ಆಲ್ರೆಡಿ ಅವರು ತೀರೋಗಿದ್ದಾರಂತೆ. ಅದಕ್ಕೂ ಮೆಮೊ ಕೂಡ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಂಗಲ್ಲ, ಅದಕ್ಕೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ಲ.
ಹಾಕ್ಬೇಕಾ ಸ್ವಾಮಿ? ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
ಹಾಕ್ತೀರಾ? Application to be filed to bring LRs of the deceased party on record. ಯಾರು ನೋಡ್ಕೊಳ್ಳಿ, ಯಾರು ತೀರ್ಕೊಂಡಾರ ನೋಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಸಂಬಂಧ
ಅಲ್ಲೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ತೀರ್ಕೊಂಡೈತೆ. ಇನ್ನೊಬ್ರು ಅವ್ರ ಅಂಗಡಿ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ 20 ವರ್ಷ ಆಗಿದೆ ಅಂತ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ. ಅದಕ್ಕೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕಿದ್ದು ಸ್ವಾಮಿ. ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಅದನ್ನ ಜೊತೆಗೆ ಮಾಡಿದ್ರ ಯಾವತ್ತು ಹಾಕಿರಾ ನೀವು?
ಅದು MFA ಕೋರ್ಟಲ್ಲಿರೋವಾಗ 2 ರಿಟ್ ಪಿಟಿಷನ್ MFA 2 ಕನೆಕ್ಟ್ ಇತ್ತಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹಾಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ. ಅವಾಗ 2017ರಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್. ಒರಿಜಿನಲ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು ಆ ಸಾಹೇಬ್ರ ಆ ಕೋರ್ಟಲ್ಲಿ. ಅದೆಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
ಮೇಡಮ್ ಧನಲಕ್ಷ್ಮಿ, ಜಸ್ಟ್ ಅಡ್ವೈಸರ್ as to what should be done in matters like this. ಅವ್ರ ಜೊತೆ ಕುತ್ಕೊಂಡು ಅವ್ರ ಸಹಾಯ ಕೇಳಿ, ಅವ್ರು ಸಹಾಯ ಮಾಡ್ತಾರೆ. ಓಕೆ. ಕಾಲ್ ಆಫ್ಟರ್ 2 weeks, 2 ವಾರ. ಓಕೆ. ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ನೀವು?
ವಿಜಯಪುರ, ದೇವನಹಳ್ಳಿ ತಾಲೂಕು, ವಿಜಯಪುರ.
ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ಇಲ್ಲಿಗೆ?
ದೇವನಹಳ್ಳಿ.
ಇಲ್ಲೇ ದೇವನಹಳ್ಳಿ. ಓಕೆ. ಆಗ್ಬೇಕು. ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. 2 ವಾರ ಬಿಟ್ಕೊಂಡು, 3 ವಾರ ಬಿಟ್ಕೊಂಡು, 3 weeks ಬಿಟ್ಕೊಂಡು ಕೊಡಿ. 3rd of March.
As per your lordship direction, I kept the respondent present, my lord.
Lordships, I pray for the correction in the
It is
There is a correction in the order.
Correction.
Yes, my lordship. I have
Another-
submitted an IA 1 of 24, which has been heard by the court. It's pending for the correction.
ಅದರಲ್ಲಿ correction ಆಗ್ಬೇಕಾ?
Howd, sir?
ಏನ್ correction ಆಗ್ಕೊಡ್ರಿ?
The case was disposed on 30th October, lordship, and thereafter one more IA was filed and it was rejected. And whereupon the court has heard the matter and found that there is some
That request
correction to
after
be
this we will consider. We'll see. Not now.
It
You
was
want
spe-
justice or you want order?
both, my lordship.
Then both you will not get. We'll say it, let it go before some other.
Yes, ma'am. He is present before the court.
Yes, sir.
Dr. Sandil Nathan, the respondent, ma'am.
Something can be done in the matter.
No, my lord.
Nothing can be done. But you agreed before the family court to do certain things.
I honored it, my lordship.
Sir,
I honored it, my
But
lordship.
what was agreed upon? What you, how
Yes,
you
my lord.
honored that? Just
I'll produce it.
ಅವ್ರಿಗೆ copy ಕೊಟ್ರಾ?
ಕೊಡ್ತೀನಿ sir.
It's a joint affidavit, my lordship. It's in page number.
Please be seated. Be seated. Be seated.
Please take that, madam.
Yes.
As per annexure 1 and 2, my lord.
Page number?
That is page number 10, my lord.
Page 10.
10 and 11, both, my lord.
What was the memo? Joint affidavit you had?
Joint affidavit is, both are, the withdrawal of the petition.
Ah.
And stating that I'm going to give accommodation to the petitioner.
So you gave an impression to the court
Yes,
that you would be providing accommodation
yes, ma'am.
and court acted upon that.
Yes, acted upon that and dismissed that petition without drawing a decree.
That's all right.
Agree.
That is what you have said
Then-
to the court. Court acted upon your word.
Yes, ma'am.
Yes.
Annexure 3, my lord.
Now, let us see the joint affidavit.
Yes, ma'am.
Read that.
Yes,
But generally, when handwritten documents are filed, typographed copies also need to be filed. Anyway,
yeah,
now it's all right. We'll
Okay,
understand
ma'am.
because parties are here. Just read that, sir. We are parties to the above petition.
yes, we are parties to the above petition. The
Ah.
petition is filed seeking for restitution of conjugal rights.
Correct.
We are ready and willing to live together
Ah.
without any conditions to each other, except husband has agreed to set up a matrimonial home at Bangalore
Yeah.
for his family and be shifting to Bangalore on weekends and other holidays as long as required. That he'll be continue to be present at Madurai. At that time, he was working at Madurai.
Read further.
Yes, ma'am. In view of the facts, the above case disposed of in the ends of justice, ma'am.
This is the prayer
Yes, ma'am.
together you made,
Yes, ma'am.
where a specific assurance is given to the court and to the gentle lady
Yes, ma'am.
that you will be establishing a matrimonial
Yes, ma'am.
home
Yes,
at
I'll
Bangalore.
come to that. Page number 12, my lord. Page number 12 and page number 13, my lord.
Page 12.
Yes, 12 is the agreement of lease.
This is in Tamil,
Yes, my lord. She knows Tamil, man.
but we should know. Anyway, Tamil is also very old
Annexure 3,
classical
my lord.
language, no issue. But just explain this to us.
Yes,
now.
yes, my lord. In view of the orders, in view of the
fact,
in view of the joint affidavit, my lord.
Tamil is a
Yes.
great language, it is said
Oh,
by
sorry.
the apex court. It's Tiravallava's Tirukkural
Yes,
is a great work
yes, ma'am.
on par with our Sarvagnas Tripadis.
Yes.
Yes.
In view of the joint affidavit, my lord, I have taken up 2 places, one at Bangalore, one at Madurai, and the other one at Bangalore. For the purposes for the petitioner to live. That is.
Sir, alone to live.
Yes,
So he will not join them.
yes. At that time, they wanted to live together. So we had a residence in Madurai and also in Bangalore. Because she was working in Infosys at Bangalore and he was working at Madurai. Then later on, I shifted to Bangalore, and I taken up this premises. That is page number 13, annexure 4, my lord.
Rental agreement.
Yes, rental agreement.
This is drawn on a stamp
Yes, my lord.
What?
It is on a stamp paper, 100 rupees stamp paper, my lord. And
This is 28th September
Yes, my lord.
2014.
Yes, my lord. 20th September 1914, 2014.
The other one is 15th October 2014 in
Yes, my lord.
Tamil.
Yes, man. That first one, 15/10/2014,
This is
2014.
with regard to Madurai.
Madurai property, man.
Where he
Madurai
would-
rental, yes, my lord. Rental premises at Madurai.
Ah.
And the one, Annexure 4 is the rental premises in Bangalore.
Yes.
She did not join me in
Where?
both the places. Even after taking these two premises, abiding by the order of this family court, the petitioner failed to join.
Where is that?
Nothing on record, man.
Then
No, failed to join me, man. That's it.
Did
For
you
the-
ever
No, no,
call?
for the simple reason, my lord, I'll.
Did you ever call
Yes, yes, my lord.
saying,
Umpteen times we have called her
where is that?
Over the phone, done in
over
good
the.
faith.
Please, sir.
Over the phone, my lord. It was done in good faith, my lord.
Over the phone?
Yes, my lord.
How many phone calls you did approximately?
Approximately maybe around 7 or 8 times, my lord.
After 7, 8 times, when she did not join, could you not send a letter? Both you are very educated, capable of running the cases on your own, excluding the bar members.
She has been deserting me.
Did you send any message in your phone?
No, my lord.
Are you in the habit of sending message, good morning, etc. to your friends? You are.
Not much, but still.
So you will not greet anybody in the life at all.
No, not like that.
You greet.
No.
You greet people. You greet people. Why did you not send a message to the madam saying, I have made you several calls. I have established a beautiful matrimonial home at Bangalore, one, and the other in Madurai. At least in Bangalore, on your assurance, I did this. Why can't you come and stay?
Because this sort of a thing had been happening several times.
No, where did you say? These are all oral things.
No,
We
my
go by evidence. You are a very good gentleman, all right. But law says, whatever gentleman says should be we should be viewed in the light of the evidentiary material.
Hardly 40 days after marriage, she deserted me, my lord.
No, but that question would not arise because all that pales into
Because
ignorance after you gave an assurance to the court that we want to live together. So that don't rake up that one. Don't link it to this one.
This is
after
this
your assurance to the court. Why you could not keep the assurance is the question.
Because desertion is a habit for her, my lord. Desertion is a habit for her, my lord.
From which date it was habit?
We married in 2006, June. We were together hardly for 40 days post-marriage. She deserted me from Madurai.
Correct. Only thereafter these assurance are given.
Yes, my lord.
May I submit here?
No, please.
I'm sorry.
Parties here.
I'm sorry.
Generally, when parties are before the
I'm
court,
sorry, ma'am.
we should interact with the parties. The version of apex court. See, she deserted only 40 days. Also, you could not live together. Well, and you understand. But all that stands condoned when you made assurance to the court, coupled with assurance to the party, your spouse, that we are going to live together. Thereafter, why? What happened to fall apart?
Because I came to a conclusion that she is a cheat.
Where have you? How you can form that?
Because
opinion?
desertion has been a habit for her, my lord.
That's why did you go for assurance to the court then? When the marriage took place?
I believed in her.
When the marriage took place?
2006 June, my lord.
2006. When the assurance was given to the court?
14, 2014.
So after 8 years, you said we are living together.
By that time, already she had deserted me twice.
By that time, all right, but after there, you have given the assurance.
Yes, my lord. Again, she deserted me, my lord. What will I do?
Where is the evidence to say? Where did you tell her that I have established a matrimonial home? Please come and stay with me.
She is a party to it, my lord. In the Madurai rental agreement, she has signed it as a witness.
Agreement.
As a witness.
Can we have this matter in chamber?
Yes, my lord.
Because it's a matrimonial matter. If you agree, we will have this matter in the chamber. Otherwise, we will hear here only in the presence of all people in the chamber. Okay. 1 o'clock?
Yes, my lord.
1 o'clock will be convenient to you? Come with open mind. Make some prayers to the God, Sun God, then come with clean mind. You may decide on your own whatever. And we will decide on our own is another thing. But when you come to chamber, come with clean heart, clean head, clean hand. Okay? To both of you. Post this matter for chamber hearing consistent with the decision of apex court. Okay. I'll post this matrimonial matter for chamber hearing. Okay. Yes.
My lord, connected matter, my lord, it's served. 7.1, same parties. And it's a common order of the tribunal.
Mr. Shankar is for assessee.
No, this
Is an acknowledgement that will go now.
7 is not ours, my lord. 7 and 7.1.
7 is?
Not
Ali,
I
yaru-
am appearing for 8, my lord, sorry.
You appear in 8. 7 ನಲ್ಲಿ
Take fresh step.
fresh steps ತಗೋಬೇಕಾಗ್ತದೆ no?
We'll take. Connected matter, same party, my lord, it's served.
ಬಟ್ ಒಂದ್ಸರಿ ಸ್ಟೆಪ್ಸ್ ತೊಗೊಳ್ಳಿ ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿರ್ಬೋದು ಬಟ್ ಇದ್ರಲ್ಲಿ ಆಗ್ಲಿದ್ರೆ fresh steps within 1 week. Failing which appeal stands rejected. Yes.
But my lord, connected matter, my lord, there is a delay. Serve ಆಗಿತ್ತು 211 days delay.
7.1 ಒಂದಲ್ಲಿ 211.
11.
All right. 500 rupees, the 211 means 422. 450 rupees the other one book ಹೇಳಿ. ನೋಡಮ್ಮ. Application ಅವರು subject to the condition. ಅದನ್ನ ಇದನ್ನ ಕೊಡಿ. ಬ್ರಹ್ಮಪುರಿಯ ಭಿಕ್ಷುಕ ಬೈ ಶತಾವಧಾನಿ.
ಅಲ್ಲ ಒಂದ್ಸಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಓದಿದ್ದೀನಿ ನಾನು.
ನೀವು ಓದಿರಾ? ನೀವು ಓದಲಿದ್ದ ಒಂದು ಪುಸ್ತಕ ಹೇಳಿ. ಮಹಾಶ್ವೇತೆ. ಕೊಟ್ಟಾಯ್ತು. ಬೇರೆ ಮಹಾಶ್ವೇತೆ. ಅದು ಆಗಿದೆ. ಬೇರೆ ಯಾವ್ದಾರ ಹೇಳಿ. ಡಿವಿಜಿ ಅವರ ಅಂತಃಪುರದ ಗೀತೆಗಳು ಕೊಡಿ. ಅಂತಃಪುರದ ಗೀತೆಗಳು 3 ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಅದು 120 40 ಅಷ್ಟೇ. ಅಲ್ಲ 3 sets. Next. Philip.
My lord, this matter is basically, my lord, one round of litigation took place. That is the very same assessment here, and this High Court has passed an order.
ಸ್ವಲ್ಪ ಮೈಕ್ ಉಪೇಕ್ಷ. ನಿಮ್ ಧ್ವನಿ ಎಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಕೇಳ್ಬೇಕು ಅದಕ್ಕೆ ನಮಗೆ ಕೇಳ್ತದೆ.
Sorry, my lord.
ಅದೇ ಅಲ್ಲಿ ಬಹಳ ಜನ.
The issue, my lord, the issue, my lord, is that, of course, it has come for condemnation, be that may. This is for the assessment year 2005-6. No, the appeal itself is not maintainable. I'll give you 1 minute, then you'll not. It's not. I never oppose condemnation up to 500 days as a matter of, but it's a very peculiar case, my lord. The very same assessment year, the department passed an order. By and large, the same income that is there before your lordship now. And the matter went to tribunal. Tribunal held in my favor. It came to this court, and this court held this money is not accessible in the hands of this assessee at all.
That was one for particular assessment.
For the very same assessment here.
Very same assessment.
Very same assessment here. Now, after the High Court order, they had in the meanwhile search has taken place. They held back saying that these are incriminating materials. According to my lord, when this court has held that this income is not accessible in the hands of this assessee at all, the question of again
of the incriminating material will not arise at all.
I'll look into the old records, my lord. Then I'll leave it is. Any short time, my lord. Very short
Application
time.
allowed. 1,000 ರೂಪಾಯಿ ಯಾವ್ದಾರ ಒಂದು ಬುಕ್ ಹೇಳಿ. Law and Social Change by Wolfgang Friedman. It's a good book. Padi. One ಎರಡು book padi. All right, 2 books to the library. Delay convert. Week after next.
No, it is correct.
Alle.
According to us,
application they'll heard panel counsel and learned senior advocate appearing for the SSC. Structure ಮಾಡಬೇಕು. All right. The question of treating it as incriminating material arises where income is assessable for tax. Otherwise, not easy, Your Worship.
That is one of the contentions. According to me, apart from that, assuming increment is that the same income they have assessed. What they assessed then, they assessed here also. There is nothing more than that, and this court.
So what applies to that will apply here also.
Here also. And according to me, it is not accessible at all. The question of appeal being maintainable is the issue point.
The small note madikambari for
not-
us to, for
not
me to
file-
learn. it,
not
for me
file
to
ಮಾಡ್-
learn. Yes.
I'll file along with the earlier order of the High Court.
Well, just try and pass on.
4 or 5 pages.
Okay.
I'll file it in a little earlier only so that you'll all will have the reading it when your leadership read the admission.
Yeah.
I will take notice, but it's monetary limit, my lord, subject to what my friends have discussed.
Okay. Yeah. Shri, so and so on request accepts notice for a respondent SAC. Yes.
Lord, the matter may be listed next week, my lord.
Ah.
I'll just see whether it's below the monetary limits.
The addition
My lord, whether
itself
it's covered
is
under the
So
exception.
the limit.
much before monetary.
If it is covered under the exceptions, but next week, my lord,
Next week at the request of. Yes.
Because I'll do the needful in 1 week, my lords. The matter is coming up first time.
Third time.
Yes, my lord. Before court first time, my lord, before register. I'll just do the needful in 1 week, my lord. So I have to file something.
Needful. On put pustaka kodi. Mullah's key to Indian practice.
Yes, my
Norma. Key to Indian practice kodabeko. 2 weeks granted. To the library. 2 copies. 2 copies. Yes.
But this will have to be dismissed. my
Alle
lords.
trial court library. Ali koda. Covered by this one?
Below monetary limit. my lords.
No. ಇದೇ ರೀತಿಯ ಆರ್ಡರ್. Okay? Yes.
Lord, the connected matter in 191 of 24, your lordship has already ordered me to on cost. This may kindly call 2 weeks since.
ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದರಲ್ಲಿ ಇದೆ ಎಲ್ಲ ಇಂಡಿಪೆಂಡೆಂಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್
Same cost.
ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ವೈ ಟು
Criminals order, common order for 2 years.
ಆಲ್ ರೈಟ್ 1 week for complaints 2 weeks. Yes, finally. Next time heavy costs will be levied. Yes.
Please, appealing for respondent 4 to 6, my lord. Lord, we had filed an application for vacating the interim order. I be given 2 days time for compliance of office objections. I've done 50% is done, a little is remaining.
No, we'll do it next week.
Please.
Once time, please. 1 week at the request of
After 15th or in it?
15.
After
Mr. Rao?
Any day.
Any day.
No. After 15th.
Next week, my lord, please, I request.
Monthly comply ಮಾಡ್ಬೇಕು.
Now, 2 ದಿವಸ ಇವತ್ತು ಕೊಟ್ರು ಇವತ್ತು end of the day ಮಾಡ್ತೀವಿ.
No, nothing is going.
Interim order ಇದೆ ನಮಗೆ ಕಷ್ಟ ಆಗ್ತದೆ. I am the purchaser. Benefit purchase.
10th, if it is convenient to the
10th
Monday.
Monday ನಾವು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಟು ಟ್ಯೂಸ್ಡೇ ಹಾಕೋಣ.
Yes, my lord.
I am going out of town.
All right, ಯಾವ ಡೇಟ್ ಹೇಳಿ ಮತ್ತೆ?
After 14th, any day, 14th or 15th,
15th.
any day.
Lord, Saturday.
ಅಲ್ಲ
17th.
18th ಹಾಕೋಣ?
Yes, my lord. Much
18th.
obliged.
Full stop. In the meanwhile, office objection to be addressed
Yes.
by the council appearing for the contesting respondent. Okay.
Maybe request for 20th.
20th. All right, 20th. 2 days na ಏನಾಗ
Interim order may kindly.
interim order to continue till then.
Great.
ನೋಡಿ
Lord, 127 days delay.
delay condoned. ನೋಡಮ್ಮ. 2 weeks. Next.
The questions of law, my lord, in page number 8.
It may be posted for admission next week, my lord.
All right. Post week after next for admission. Okay. But identical question ಮೇಲೆ admit ಮಾಡೇವಿ ನಾವು.
ಇಲ್ಲ ಇದು
2 matters ಅನ್ನು admit ಮಾಡಿದೆ. I remember, I read these papers. Anyway, just look into. Yes, call after 2 weeks. Next.
181 days, my lord.
181 days. ಒಂದೆರಡು ಪುಸ್ತಕ ಕೊಡಿ, DVG ಅವರು ಪುಟ್ಬಿಟ್ಟು ಬುಕ್ಲೆಟ್ಸ್ 20 ರೂಪಾಯಿ ಏನೇನೋ ಇದೆ. ಸಂಸ್ಕೃತಿ ವೆರಿ ಗುಡ್ ನೋಡಮ್ಮ. 3 books to Calgary Court Library by DVG.
There's another small book, my lord,
Devaru is also
wonderful.
very good. Devaru, on Devaru there is one more A. Murthy Rao's Devaru. Very good book it is. On that, on English there is one
That
famous
is a
book.
much larger. This is very small. DVG.
But there is one English book by Richard Dawkins, the great evolutionary biologist. He writes God Delusion, one of the finest books. His books are excellent. The Blind Watchmaker, Magic of Reality, Genes, Selfish Genes, great works they are. Just whenever you get time, just glance. Okay.
Lord, this is, my lord, page number 7, my lord. It can be admitted, my lord. 15. 2 questions of law, my lord, page number 7.
ನೋಡಿ page 7 ದಲ್ಲಿ appeal admitted following on the following substantial questions of law ಅವನು reproduce ಮಾಡಬೇಕು. ಓಕೆ. ಧನಲಕ್ಷ್ಮಿ
for the accused in this
ಕಂಪ್ಲೇಂಟ್
matter.
ಆಗಿದೆಯಾ? ಮೇಡಮ್
ಅವರೊಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ saying that we are not paid the interest and pension is revised pension is not paid. Counter affidavit ಆಗ್ತೀನಿ next week ತಗೊಂಡ್ರೆ
ಕಾಲ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ at the request of ಮತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು. ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಕೇಸ್ ಫೈಟ್ ಮಾಡಿದ್ರೆ ಪೆನ್ಷನರ್ what he should do. See how pensioners are treated by the apex court.
ಇಲ್ಲಿ ಇಲ್ಲ ಅದು ಇಶ್ಯೂ ಇಲ್ಲ. Milords, it was a promotion to be given, Milords. We have given 2 promotions as per the court order. ಏನ್ ಡಿಫರೆನ್ಸ್ ಬಂತು arrears, even that is paid. Notionally ಏನಿದೆ ಪೇನು ಫಿಕ್ಸ್ ಆಗಿದೆ. Pension to ನಮ್ಮ ಕೈನಲ್ಲಿಲ್ಲ. We have forwarded the papers to the pension authority, Milords. And in respect of the interest, Milords, there is no order by the tribunal or this honorable court is our contention.
I think in Padmanabha Nair versus perhaps Union of India, 83 Supreme Court says, just look into.
Please, ma'am.
83 Supreme Court. It says where pension is paid belatedly.
ಇಲ್ಲ ಇದು pension belated ಆಗಲ್ಲ.
Differential.
ಅಲ್ಲಲ್ಲ ಏನಾಯ್ತು, they were not entitled for a particular.
Anyway, you file that.
That I will
just
file it.
into that judgment. That is followed in a Chandrasekhara Kambara versus Bangalore University. Okay, ILR 2006-7, something like that. Just look into.
Please.
Yes.
Much.
Right. One request we want to make to you,
please,
because you appear for the employer and state is the largest litigant, the central government also. When it comes to the issues of retired people, you should be very, very soft, consistent with apex court decision in DS Nakara versus Union of India. That generate matters there, because we have seen in some matters only some ritualistic objections are taken only to trouble the pensioners. That may not be. Just advise your clients.
Please.
Yes.
Much.
With 17, Milords, the transfer pricing matter, Milords, delay of 105 days.
11 admit mana similar matter ongoing ide like.
Yes, sir.
Nodama admit it on the
1 to
following.
7. 1 to 7.
1 to 7.
We've raised 8 questions. Public.
Yes. Yes, Ravi. 179 days. Condemned.
Notice has to go.
Notice ಹೋಗ್ಬೇಕಾ? Okay. Notice. Emergent notice.
Sir, emergent. Very notice.
Yes, Mr. Joseph.
The respondent.
Now, Mr. Ravi Raja, we wanted to say something. What is that?
Please.
What you wanted to read? You are holding a book in your hands, na?
ಇಲ್ಲ 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 ಇದು cost.
Notes, this is a matter where the arbitrator has terminated notes in the proceedings for non-payment of fees. This is a matter, my lords, where the arbitrator has terminated the claimant's proceedings for non-payment of fees, my lords, when we had deposited that money as on the last date, which was provided by the arbitrator. Thereafter, my lords, the arbitrator sought to return that amount to us. Not only that, though the respondent therein, who is the respondent herein, had agreed, my lords, that in the event of my default, they are ready to pay. Under section 39, my lords,
He
if
can
they
pay.
Please,
And there
my
can be order for reimbursement also.
Please, my lords, it could be done. Act itself says that if either of the parties don't pay, in fact, before I paid, before the deadline came, they had offered. Arbitrator says, no, let them pay. If they don't pay, I will terminate it, which is contrary to the mandate of the act. Not only that, my lords, my right to contest the counterclaim is taken off. What was fixed was my claims, fees regarding my deposit regarding my claim, not regarding the counterclaim. Thereafter, counterclaim was filed. I have filed the statement of defense. My right to contest the counterclaim is also taken out by the arbitrator. Thereafter, my lords, what happened was emails were being forwarded to us. After the termination, thereafter, we did not receive any email. We thought, my lords, matter was dormant.
Don't spell out the name of the arbitrator. Which is that page?
Please, my lords. My lords. Lords, page 187.
Yes.
My lords, insofar as this, if my lords, provision, my lords, of section.
Perhaps legal position, Ajesh Kumar will not deny at all.
Deny that, my lords. Lords, my only, now, my lords, I am informed that there was our interim measures application was rejected. An appeal was, statutory appeal was filed before the civil court. In the reply statement that they had filed, we came to know, my lords, that arbitral tribunal proceedings were going on, continued to go on, and that the matter, my lords, was reserved for award. Thereafter, we came before this honorable court. In the meantime, my lords, on the ground, my lords, that there was no equal treatment of the parties, we had sought for recusal of the arbitrator also, which application is pending under section 13 before the arbitrator. That has also not been considered. Lords, it is an admitted fact that as on the last date,
Ajesh, why can't you be reasonable? Like, you can have some you can't force some arbitrator to decide that. Choose some arbitrator.
Can I just say this, my lord?
Yes.
With all respect, my lord.
Yes.
My lord, what happened is both parties, my learned friend's client had filed an application under section 9 before the trial court, which came to be allowed. As against which we came before this honorable court on appeal. This honorable court, my lord, with the consent of the parties, in fact, both of us discussed it, and we sought the consent of the honorable arbitrator and appointed the arbitrator. Now, the arbitrator, my lord, was given the timeline to adjudicate on section 9 and 17. Now, the honorable arbitrator, my lord, at that stage, never even asked for fees. Both parties submitted their arguments. Their application under section 17 was rejected. After that, my lord, the honorable arbitrator sent a letter to both of us saying, look here, both of you have not yet paid my fees. This is after the order is passed. At that stage, my lord, the representative of the claimant writes a very scandalous mail after the rejection of the section 17 application. Writes a scandalous mail, which I may be permitted to place. My lord, I've filed a copy on the other side to the honorable arbitrator saying that you please recuse yourself. It is not the claimant, no application. His son-in-law files a letter saying that you have done this after the section 17. Now, my lord, after that, despite that letter, they wrote a letter to the arbitrator, sir, we want some more time to pay fees. The arbitrator said, I'll give you more time. Now, when my learned friend is right in saying that the arbitrator terminated their proceeding, after
he's one of the very respectable retired judges of
yes,
this
my lord.
court.
And I just may be permitted to place on record.
Anyway, we will tell him to withdraw that, all that.
No, not that.
On that, if we go on making
I'm not on that. All I'm saying, a very simple solution.
Yes.
They file an application before the arbitrator for recalling the order. There's judgment to that. My lord, the arbitrator is entitled. Please see this, my lord.
He can recall the order.
He can recall the order. They should show sufficient cause.
ಇಷ್ಟೆಲ್ಲ ಮಾತಾಡಿದಾಗ ಏನಾಗ್ತದೆ ಅದೇ arbitrator.
He has not taken it. I'm being very.
I know he's a tall judge. Still, justice should seem to have been done.
My lord,
we are on that. Choose any arbitrator of your choice.
My lord, it's not on that, my lord. I'm only saying this. When they suffer an order, after they suffer an order, my lord, the entire process is to be completed in 6 months. we were having day-to-day sessions. After having day-to-day sessions, it is their choice of the honorable arbitrator. I conceded. The honorable arbitrator heard my learned senior friend, conducted the hearing, passed an order. At the stage, my lord, when he requests his fees, nothing more. And they say, sir, I'll pay you today, tomorrow.
I thought you have said that, all that you have
Yes,
said now.
and please see
Well,
the letter.
if you want
my lord.
us to pass an order, we'll write the judgment,
My
is
lord,
another thing. But same treatment you will have in a similar set of facts when you come before us. Therefore, we are saying he's a tall arbitrator. Now, all these things have happened. Even he may feel a little embarrassed to treat the matter. Maybe he may not also. But in the fitness of things, choose an arbitrator of your choice.
My lord, I bow down to what falls for my lord.
Yes.
My lord,
In
let
some
me take
matters,
instructions.
we have given that relief to you also.
My lord,
Just 2.5 years
yes,
ago.
let me take instructions for my client, my lord, because I don't want to say something which, because what's happened is, my lord, when if I may just permit it to show, my lord, not to say anything. I've served a copy on the other side. I'll just, sorry.
Any allegation against the arbitrator of that stature, you have to withdraw. Unconditionally withdraw.
We will do that.
Coupled with a sorry also.
Yes, I will do that.
Yes,
I
you
will do
can't.
that.
Otherwise, no, tomorrow, no judge will be able to do job. No arbitrator will be able to arbitrate. No farmer will be able to till the land. No merchant will be able to sell the grains.
Lots. In fact,
You can't go on.
we appeared before I appeared before the arbitrator along with the learned friend.
We saw that judge. We have argued many
Please,
matters
please,
before
Lords,
him. He's one of the tall judges of
I
this
get it,
court.
my lords, and we have not vouched for those. In fact, we have said don't do that.
Why
But-
your client's son-in-law writes a letter like that, nasty letter to the judge?
No, my lords, what he has said is,
Who is he?
No, he was the official representative because emails are addressed to him. Here, my lords, what had happened is my lords,
See, one thing, Mr. Anian, you are a tall member
Please,
of the
my
bar.
lord, I
And
get it.
additional advocate general
Please, my lords,
also.
I get it, my lords.
These are all the feathers in your cap.
Please, my
So
lords.
stand taller.
Therefore, my lords, we will unconditionally withdraw that, my lords. Not only that, there is, in fact, my learned friend also should be fair. We were discussing the matter for actual the main settlement itself.
ಇಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವೇ ಕುತ್ಕೊಂಡು
But the moment
ನಮ್ ಶಂಕರ್ ಇವ್ರ
No difficulty,
ಯಾರು ಒಬ್ಬ ಟಾಲ್ ಜಡ್ಜ್ ಕೂಡ್ಸ್ಕೊಂಡಿಲ್ಲ
No difficulty.
ಅಂಡರ್ ದ
It's a commercial matter. It's a commercial matter. There's no difficulty at all.
ಮಾಡ್ಕೊಂಬಿಡಿ.
Yes, my lord. It can be learned senior counsel.
ನಮ್ಮ ಶಂಕರ್ ಅವ್ರಿಗೆ ಹೇಳೋಣ. ಶಂಕರ್ ಜಿ ಬರೀ ಒಂದ್ ಕೆಲ್ಸ ಇದೆ, ಬರೀ ನಿಮ್ ಜೊತೆ. Both the sides having argued the matter stood taller than what they appear usually and agreed to have mediation at the hands of learned senior advocate Mr. Shankar. First off, this is really appreciable. First off, parties to share all papers and information with the learned mediator and fully cooperate with him. Inter-alia by promptly paying the fees prescribed by him in his wisdom and virtue.
Absolutely. Bow down, please.
When matter to be called. ಈ ಮತ್ತೀಗ ನಿಮ್ ಪಾರ್ಟಿ ಕರ್ಸಿ ಕುಡಿಸ್ಬಿಟ್ಟಿರೋ ಮತ್ತೆ ಸಿಗಲ್ಲ ಅವರು.
It will not take
ಬೇರೆ
more than half an hour.
ಕೂತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
My lord, if both parties have an open mind, not more than 30 minutes.
That's what. Most of the problems, I tell you, most of the problems arise. There is one famous book, the Reader's Digest published 7 best books ಅನ್ಕೊಂಡು ಒಂದು book ಅನ್ನು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರು. ಅದರಲ್ಲಿ ಒಬ್ಬ ಲೇಡಿ ಬರ್ದಾಳೆ, How I Saved My Marriage ಅಂತ. I have committed all the sins which in regular jurisdictions would constitute sufficient ground for divorce. One lady writes, but my friends are so virtuous, they have not committed one of the sins which I committed, and they could not save their marriage, but I could. ಸ್ವಲ್ಪ ನಮ್ಮ GS ಶಿವರುದ್ರಪ್ಪನವರೊಂದು ಒಳ್ಳೆ ಎಲ್ಲೋ ಹುಡುಕಿದೆ ಇಲ್ಲದ ದೇವರ ಕಲ್ಲು ಮಣ್ಣುಗಳ ಗುಡಿಯೊಳಗೆ ಅಂತ ಒಂದು ಪೋಯಮ್ ಇದೆ. ಅದರಲ್ಲಿ ಒಂದು ನುಡಿ ಬಹಳ ಚೆನ್ನಾಗಿದೆ. ಐ ಶುಡ್ ಕೋಟ್ ಇಟ್ ನಾವು. ಹತ್ತಿರವಿದ್ದು ದೂರ ನಿಲುವೆವು, ನಮ್ಮ ಅಹಂನ ಕೋಟೆಯೊಳಗೆ ಎಷ್ಟು ಕಷ್ಟವೋ ಜೀವನ ಎಂಬುದು 4 ದಿನ, ಎಷ್ಟು ಕಷ್ಟವೋ ಹೊಂದಿಕೆ ಎಂಬುದು 4 ದಿನದ ಬಾಳೊಳಗೆ. ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್.
Yes, absolutely.
Self adjustment. Next Sanjay is even more important. It is on tongue. ಅದು ಎಲ್ಲಿದೆ ಬಂಧನ ಎಲ್ಲಿದೆ ನಂದನ, ಎಲ್ಲ ಇರುವುದು ನಮ್ಮೊಳಗೆ, ಒಳಗಿನ ತಿಳಿಯನು ಕಲಕದೆ ಇದ್ದರೆ ಅಮೃತ ಸವಿಯಿದೆ ನಾಲಿಗೆಗೆ. If you have a sweet tongue, you can sell bitterest pills to people at higher price.
Yes.
If your tongue is bitter, even 1 milliliter of honey also you cannot sell. Really.
Grateful, my lord.
Sit with
Yes, ma'am.
the toilet. Okay.
Yes, yes,
We will do
absolutely.
that. Thank you.
Grateful, ma'am.
We'll have it after 2 weeks.
Please,
Call after 2
Lords,
weeks.
as further hearing.
Come, let us see.
Please.
You have should repose faith in all
They
that
are
is
not
something
going to
what.
press.
Yes.
Grateful.
Interim order to continue.
Please.
Okay. Yes.
Orders of the DRT, DRAT are under challenge. But the case plots so transpires, lords. Respondent number 1 is the borrower. Respondent number 2.
You are guarantor.
No, I am the bank, lords. I have to
The bank.
recover. No, DRT, DRAT orders are under challenge. FCNR deposits, lords, respondent 6 to 26. The authorized, please, lord, the respondent number 2, their consultant, who is also the borrower, to place this with us. No sooner, lords, the account was declared as an NPA. But we approached the DRT, DRAT, lords, we adjusted the amount. That, my lords, only as against, my lords, the respondent number.
Take notice, emergent notice.
Emergent, let's say, they all live abroad. Can I take it, my lords? Might be permitted, not take it on the, this council who has appeared before the DRT.
But abroad is the servicing protocol. There is one order in CPC. When they are abroad, all petitions should go to the foreign ministry.
Please.
Foreign ministry will look into everything.
Yes, my lords.
Then it will decide to send or not to them. Because suppose, ಈ ದೇಶ ಹೆಂಗ್ ಹೊಡಿಬೇಕು ಅನ್ಕೊಂಡು ಒಳಗೆ ಬರ್ದಿರ್ತೀರಪ್ಪ. ಅವಾಗ, therefore, that order is made. Very beautiful, Mr. Nagesh, there is a very famous judgment of Bombay High Court by, why that procedure anta. ನಾವು ಅನ್ಕೊಂಡಿವಿ procedure ಇಷ್ಟೆಲ್ಲ ಯಾಕೆ ಮಾಡ್ಯಾರೆ ಅಂತ. That's what, that way. Okay, third, petition, issue emergent notice. In addition to taking usual steps, petitioner is permitted to serve a copy of the petition along with the documents on the counsel who represented the respondents before the DRT
and
the DRAT also. ಇಬ್ರು ಮೇಲೂ ಮಾಡಿಸಿ.
Please. So are you.
Yes. Yes, sir.
Land grabbing. What I have questioned is the order directing framing of charges against me.
It appears covered by the judgment also, which you had argued, Chandini. So we'll issue notice and stay. You file your objections. Which is that judgment? Bring that judgment also. Correct. Issue emergent notice. Interim order as prayed for. Chandini madam is requested to accept notice for first respondent. Emergent notice to the second. Second also. First, state by Bangalore SHO Metropolitan Task Force. BBMP. Or BBMP. Shri Panel Council. Shri.
BMTF. BMTF is also state.
State only.
State only. Police.
Police.
It's a separate panel.
They have panel advocate.
Because they function from within the BBMP office.
Very well. No issue. Kartikeyan. But in one matter where he has argued that RP Sharma versus state, BMTF is held to be a police station, which he had argued. It's the reported judgment. Anyway, for this one, yes. Yes.
Petition, my lord. Well, challenging the order passed by the state commission, my lord, dismissing the appeal filed by the petitioner as it is barred by time, my lord. My lord, the respondent files a consumer complaint in the district.
ಅಪೀಲಿಗೆ ಎಷ್ಟು ಟೈಮ್ ಇದೆ?
45 days, my lord. Section.
ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇಗೆ ಎಷ್ಟಿದೆ?
Swami,
ನೋ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ.
I have filed an application under section 5, my lord.
Whether 5 is applicable, consumer forum is held to be not a court. If it is not a court, section 5 of the Limitation Act is not applicable. 5 applies only to the courts. Then where is the provision? Act kodi. Which is that Aditya, where Supreme Court said consumer forum is not court and section 5 is confined to only courts. Consumer forum act ellide? Consumer act tandilla. But why do you come to court? Act ildange argument. Where is Limitation Act?
The previous matter, my lord, same connected matter, this honorable court had appeared before.
So you need not bring the books at all.
No, my lord, my apologies, my lord.
Okay. All right, post, next, call this matter along with WP number, so and so, so and so. Alien condonation of delay provision ideno, Chandini, for appeals. What can hit consumer forum act 24 capital A.
Old act, similar.
2019 act.
2 years condonation of delay provision.
ಇದೆಯಾ? ಅಪೀಲಿಗೆ 2 years ಇದೆಯಾ? ಒರಿಜಿನಲ್ ಈಗ ಅಪೀಲಿಗೆ ಎಲ್ಲಿದೆ? 30 days. No provision for condonation. 51. Appeal to National Commission, 51. Yours was to the National Commission, State Commission.
State Commission, my lord. My lord, if I may, my lord, if I can make one.
ಯಾವ section ಕೆಳಗಡೆ appeal?
41 subclause 2, my lord, for the 45 days time period for appeal.
41, appeal against order of district. Any person sides, State Commission may entertain an appeal after the expired period of 45. If it is satisfied, there was sufficient cause for filing it within that period, provided that no appeal is required to pay any money. Life from. So there is a provision for condonation also.
My lord, here my one submission, my lord. This connected matter in previous case also, my lord.
ನೀವು ಬುಕ್ಕ ತಂದಿಲ್ಲನ್ರಿ, ನಿಮ್ನಂತ ಹೆಂಗ್ ಹೇರ್ ಮಾಡೋದು? ಈಗ ಸಪೋಸ್ ಮದುವೆಗೆ ಹೋಗೋದಿದ್ರೆ ಮಂಗಲಸೂತ್ರನೇ ತೊಳ್ದಂಗ್ ಹೋದ್ರೆ ಮದುವೆ ಮಾಡಕ್ ಬರ್ತದಾ? ಅದೆಲ್ಲ ಬೇಕಾಗತ್ತೆ ಅಲ್ವಾ?
Facts, my lord, one
ಏನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಐತಿ? Call next week to enable counsel for the petitioner to read and bring books, law books. Okay.
Date may be fixed.
What date? We come without books and you are saying that we don't entertain such a counsel at all. Have you ever seen any Indian peasant going to farmland without agricultural implements on his shoulders? Yes. ಇಲ್ಲೆಲ್ಲ ಓದ್ಕೊಂಬಂದು ಸ್ವಲ್ಪ ಪ್ರಯತ್ನ ಮಾಡೋರಿಗೆ ನಾವು ಒಂದ್ ಮುಷ್ಟಿ ಮಾರ್ಕ್ಸ್ ಜಾಸ್ತಿ. ಇಲ್ಲಿ ಬಂದ್ಕೊಂಡು ಸುಮ್ನೆ ಏನೋ ಒಂದ್ ನಾಟಕ ಮಾಡೋರು ಇರುತ್ತೆ, ನಾವೆಲ್ಲ ನೋಡ್ಕೊತ್ ಕೊಡಕ್ಕಾಗ. ನಿಮ್ಮನ್ನ ನೋಡಿ ಇನ್ನು 10 ಜನ ಕೆಡ್ತಾರೆ. ಎಸ್. ಅದೇ ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಯಾವ್ದೋ ಒಂದು WP ಹೇಳಿದ್ರು, ಬರ್ಕೊಡ್ರಿ ನೋಟ್ ಬರ್ಲೆ ಜೊತೆ. ಎಸ್. Yes, brother.
The issue involved in this appeal, my lord. Lord, that identical issue, my lord, has been reserved by the coordinate bench, my lord, in ITA number.
Reserved. So we'll call this matter after 4 weeks.
If they admit agli, then same thing will follow. Matter can be admitted, then my lord.
Because it is reserved.
My lords, I appear for the respondent.
Yes, sir.
My lord, may I just submit, my lords, with my lord's permission?
Yes, yes.
My lords, may just have the order dated 25th July 22, which was passed by my lords, the daily order in this case itself.
What?
25th July. My lords, it was pointed out that the review petition in engineering analysis, which is the Honorable Apex Court judgment dealing with the issue of software royalty, is pending. My lord, subsequently, the Honorable Apex Court in other cases has dismissed the review arising out of that judgment.
I mean, even that fact also.
Is also considered.
Is being considered.
Anmel, just we'll call it after 4 weeks.
Please, my lords, please, my lords.
Call after.
At the admission stage only, your lordship.
Huh?
At the admission stage only, your lordship.
That's what. Call this matter.
Deeply obliged, my lords.
After 4 weeks.
Much obliged.
Since it is submitted at the bar, submitted by learned panel counsel, that identical matter having been heard is reserved for orders by
ITA number 11.
Already.
of 2022.
22 by the coordinate bench, huh?
Please.
Okay. Next.
Matter pertains to input tax credit, my lord. The
ಎಲ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್ ಇಲ್ಲೇ ಇಲ್ಲಲ್ಲ ಮಂತೇಶ್ ಸಾಮಾನ್ಯ ತಪ್ಸಲ್ಲ. Week after next account. Call week after next to enable counsel for the assessee to come and argue. Yes.
Lord, the issue is about the petitioner is into cable television service. During the course of giving cable television service, he used set-up boxes. The question is whether set-up box is service tax payable or
Judgment decision
VAT
covered by
payable.
judgment alva.
my lords, it's a question of deemed sale, my lord. Whether where control over a device along with consideration, whether it constitutes sale for the purposes of the Constitution of India, Sale of Goods Act, as well as the taxation statute, my lord. Supreme Court in BSNL has taken a view. There is a batch of matters, my lord, on the 11th.
11th. Call this matter on 11th only.
Similar matters
issue
pending in High
notice.
Court.
Learned AG on request accepts notice for the respondents, correct?
My lord,
For the respondent. All right.
we called on 11th.
Call this matter along with correct?
ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ, I'll give it again.
And ಸ್ವಲ್ಪ ಕೊಡಿ. Along with
ಕೊಟ್ಬಿಟ್ಟು,
signs.
ಕೊಟ್ಬಿಟ್ಟು.
Okay. Yes, sir. 11th. Yes, Raviraj, any?
Lord, connected matter admitted, my lord. I didn't, same issue, on same issue.
The coordinate bench, another. Coordinate bench order? The coordinate bench in a similar matter,
ITA
that is ITA number so and so,
306 of 23,
has admitted the appeal
302 of 2000.
on the substantial questions of law that are framed in this petition also. First up, in view of that, this appeal is also admitted in terms of the following substantial questions of law. First up, call this appeal along with issue notice, call this appeal. Yes. Further hearing, PDA matter. Abhinav. Correct. We should not forget in the meanwhile, after all, memory fades. You have to do these things before memory fades. Call next week, call this matter on so and so. On date kodi. Avat
I'm filing the memo along with Google Maps and all, Mala. I collected today.
Whatever you want to do, file that. After serving copy on the other side.
Okay.
All right.
Please.
But before memory fades, you have to argue this matter. How long we can go and spending time on this? Yes, call on so and so for further hearing at the request of learned AGA, the CGP. Yes. Yes.
Sir, please.
Yes, sir.
Lord, these are.
On his leg. The Lordship may kindly pass on, my lord. Sanmati is on his legs, my lord.
He's on his feet, please. Okay. Can we do that, sir?
Yes.
Yes, pass. But just to give a few
Yes, sir.
foundational facts.
If it pleases this honorable bench. But the matter relates to assessment years of 96, 97 and 98, 99. Now it has a checkered history, so I'll just give 5 minutes. But the petitioner set up a power plant. And for that purpose, it engaged the services of a foreign company called Raytheon Basco Overseas Limited. Now, the controversy was that according to Riol, all the services were rendered offshore. It was supply and offshore services rendered. The contract is of 1995. They were in country services, but rendered by subsidiaries of Riol, and there is no dispute. Tax was paid. So here the dispute was about exigibility of tax, whether those services which are rendered offshore are exigible to tax or not. Now, the assessing officer and the CITA held against us, the ITAT held against us. This Honorable Court, my lord, on 16th March 2009, by a judgment, held that technical services that were done offshore are not exigible to tax, relying on a 2007 Supreme Court judgment of Ishikawa, 2007-3 SCC.
Was it cited before the authorities and the tribunal?
I beg your pardon, Lord?
Were these cited before the tribunal?
Before the tribunal, this judgment of Supreme Court was after after the tribunal's judgment, which was 2004 or 2005. So 2009 partly allowed the appeal. 2010, my lord, to get over our judgment, an amendment in the Finance Act is brought. Basically, my lord, what the Supreme Court had said in Ishikawa's case, where there is in-country and offshore services, offshore element, because the services are not rendered in India, will not be exigible to tax. So they laid out a twin test that the services have to be done in India and utilized in India as well as rendered in India.
Only
So
then exigible to tax.
10 only, because if it is not rendered in India, if it is only utilized in India, then there is no nexus as far as tax is concerned.
Understood the point.
And,
Let him come.
then, so there is a little history to it. I'll just take 2 minutes. Not on merits, then we'll wait for Mr. Sir. They did a retrospective amendment, saying a clarificatory amendment in Finance Act of 2010, saying that irrespective whether they have been rendered in India or not, they'll under 917, it will be exigible to tax. Now, in the meanwhile, they had also filed SLPs against the order of the division bench of this Honorable Court. So the Supreme Court, Lord, for assessment years 96-97 and 98-99, gave liberty to file a review here based on the amendment. As far as 97-98 is concerned, it was not sent back and it was kept in the Supreme Court itself. Now, Lord, 97-98 appeals got dismissed in for non-prosecution in 2017, and that's the position that is even prevailing today. As far as, Lord, those 2 years, 96-97 and 98.
Pre-amendment.
Yes, but to see whether what will be the effect of the amendment, a review was, and the review in 2015 has been allowed, and now it has to be argued. So that is that. Now, Lord, there is another issue here. In the meanwhile, the payee, that Riol, filed tax returns in Bombay, and eventually ITAT has held that no part of it is exigible to tax. Appeal is pending in Bombay High Court. That is not one part of the, as far as base tax is concerned. As far as penalty is concerned, 100% penalty was put. ITAT held in my favor, saying that there is reasonable cause under 273B. So penalty is deleted. Reasonable cause, because they say 3 things. They say that in 1997, an opinion was given by a law firm in Delhi saying that it is not exigible to tax. A chartered accountant firm also given an opinion, it is not exigible to tax. I had, my lord, moved an application seeking a no objection. And in that, my lord, I had made a detailed representation that it is not exigible to tax. Eventually, when they said, no, you have to deduct tax, it was deducted and paid, but it was slightly late. So, the ITAT held that this is a good ground, sufficient cause.
So, no penalty.
And so, no penalty. Now, as far as, my lord, the issue of base tax is concerned, finally, my lord, what will be decided in the High Court, because this is only tentative. TDS is only tentative proceedings. What is decided will prevail. But as far as penalty, today, my lord, submission is, their penalty appeal is just one ground appeal. And it can be disposed of in 10-15 minutes. Because not the position is this: in 2006, when the penalty order was against them, they filed a 1-page appeal, but they refunded us the amount. But in case, my lord, the matter is hanging fire, in case I, my lord, lose, I am confident, my lord, it's a one ground appeal. I can finish it in 15 minutes. But in case I lose, I'll have to, and it's kept pending. My lord, the interest is mounting. So therefore, and my lord, they are totally unconnected, because here it is on the basis that it is exigible to tax, but the ITAT said that because there is reasonable cause for A, B, C, D reasons, and also, my lord, in another reason was we all had this is exigible to tax or not, but unfortunately the chairman, because of personal reasons at that time, refused to hear, and my lord, that could not. So all these taking all these
It's
factors.
still pending.
No, my lord, he said it can't be heard. I have some personal reasons, so my lord, he refused to hear. And my lord, at that time, probably they could have filed a writ against that order, but it became fine. So for all these reasons, my lord, penalty. So this is where we are, my lord.
Let us see your,
Yes.
let your friends.
I just wanted to give an overview.
That's what, I got that idea. Rough idea, I got that. There was one similar judgment by Justice Dalvir Bhandari. One judgment which related to
Relating to, my lord, tax, base tax or penalty?
base tax.
Yes. Of Justice Bhandari.
Dalvir Bhandari's judgment.
I'll have a look at it.
Just
Great.
yes.
Please.
Can we come back within 5 minutes? Minutes. Yes. Some medicines I have to take. That's the reason. Otherwise,
Even if we lose the money, obviously cannot be restriction because time will it will only be academic. This past beyond 90 days. ಬೇರೆ ಯಾವುದು ಓಪನ್ ಇರುತ್ತೆ exemption ಇದೆ specifically covered. Getting into the right as going to because it will have an effect in the GS or the GS provision. On that basis, shall be mandatory. That is other market right. Marital otherwise notification specifically covered. Specific entry but DG sets are there. Correct. So we'll have it set aside on that. Because other issue was there. Last time we asked for an affidavit, etc. Even though covered it, RDS contact petition.
My lord, court is not audible.
Audible ಇಲ್ಲ ಅಂತ ನೋಡಿ. Is it audible now?
Yes, now it is audible.
Yes.
Highly obliged.
This is a short point, my lord, apart from the legal point which your lordship asked, is on facts. It is not even for this year. Where is the question of adding for this year?
But there is one aspect, my lord, there is no retraction. My lord.
ಅಲ್ಲ ಅದು admissibility level ಗೆ ಬಂದಾಗ retraction begin ಆಗ್ತದೆ.
My lord, have not retracted from the statements.
There is no admission.
Both of them who have given statements have not retracted.
No,
One
no.
aspect.
Question of retraction arises under the law of evidence. Any standard author will say the question of retraction arises where prima facie admissibility of the evidence is demonstrated.
My lord.
ಅದ್ರ admissibility ಬೇಕು. ಆಮೇಲೆ retraction ಬರ್ತದೆ. Admissible ಇಲ್ಲ ಅಂದ್ರೆ retraction ಇಲ್ಲ ಅಂತ hold ಮಾಡಿದ್ದಾರೆ.
Now, first of all, we have not made admission before the income tax authority. There is no examination of the SCB by the income tax officer. They are examined one Navneet Singhania and say that I am binding on me. They have not examined me. My examination is only with respect to CBI. That is our point.
Money was found at whose hands?
Money was not found in anybody's hands.
At all.
It is not. They are saying some company invested in some company of Jagan. That company's one statement, one person of that company said, I have given him the money. This is the factual aspect. They have not called, CBI called me and examined whatever is that evidence your lordship are aware. Now, subsequently, Income Tax Hyderabad examines Singhania and our assessing officer does not even examine. I have not given admission before the Income Tax authorities at all in this matter. Where is the question of adding me? I told them in
You said admission is given before the authorities in 2009.
Navneet Singhania.
Written that one, na?
Singhania.
Singhania. Not Ratan.
Not. He has never been examined. Let them produce a statement which they have examined. If you have any statement recorded by my assay, let them produce a copy.
Okay. Next week. Any short matter because we have one chamber hearing. ಎರಡೇ matter. We'll come in the afternoon then after. Only two matters are there.
My lord.
After come. Yes, brother.
Serial number 45, my lord. We are for respondent number 1 and 2, short accommodation.
ಯಾವ year?
Serial number 45.
45.
22.
22. ಮತ್ತೆ ಅದೊಂದು ಆಗ್ಬಿಟ್ರೆ ಕೇಸ ಇಲ್ದಂಗೆ ಆಗ್ತದೆ. ಒಂದೇ ಒಂದು ಉಳಿತದೆ. ಫಸ್ಟ್ ಓವರ್ ಇದಾವ. ಆಲ್ ರೈಟ್. 2 weeks at the request of. Entry ಮಾಡಿದ್ಯಾ?
No, my lord.
ನೋಡಿ ಇತ್ತು.
It's the advance ruling, appellate authority for advance ruling.
ಯಾವುದು?
Advance ruling authority order is under challenge. Appellate authority for advance ruling. Again, no entry model.
No entry model. Okay.
Serial number 42, my lord.
42. 42 ಯಾರು ಟೈಮ್ ತೊಗೊಂಡಂಗಿತ್ತಲ್ರಿ?
42 I am appearing. Mr.
ಇದೆಯಾ? 42. You want time?
Yes, my lord.
ಯಾವ year?
22, my lord.
22. 2 years, 3 years ಸಿಗ್ಬಂತಲ್ಲ ಇನ್ನು.
Short 1 week time.
All right, 2 weeks at the request of finally.
Entry model maybe.
Entry mod to continue till then. Okay. We want chamber hearing ಇದೆಯಲ್ಲ? ಅವ್ರು ಬರ್ತಾರಲ್ಲ ಮಧ್ಯಾಹ್ನಕ್ಕೆ. ಮತ್ತೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ ಬರ್ಬೇಕಂತೆ. ಮತ್ತೆ ಈಗ ಬಂದಾರ ಅವರು, ಅವ್ರಿಗೆ ಹೇಳಿ ಯಾವ್ದೋ ಚೇಂಬರ್ ಹಿಯರಿಂಗ್ ಹೋಗಿದ್ದಾರೆ, ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ ಅಂತ ಹೇಳಿ. Shankar is waiting for which case?
Take the correct date. Thank you.
ಯಾವ್ದೋ ಒಂದು ಮೆಟ್ರಿಮೋನಿಯಲ್ ಮ್ಯಾಟ್ರ್.
I know, man. I saw, man. Matrimonial matters require only human element.
ಅದು ತುಂಬಾ ಕಡಿಮೆ ಆಗ್ತಾ ಇದೆ.
ಎಂದ್ರೆ ಬರ್ದ್ರು ಮೈ ಲಾರ್ಡ್, ಈ ಕಾಲದಲ್ಲಿ ಏನಾಗ್ಬಿಟ್ಟಿದೆ, ಕಾಲಿಲ್ಲದ ಅಶ್ವಕ್ಕೆ ಗೂನಾದರೇನು, ನನಗಿಲ್ಲದ ವಿಶ್ವಕ್ಕೆ ಏನಾದರೆ
ಏನು
ಆ ತರ ಆಗ್ಬಿಟ್ಟಿದೆ. ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಫೈಟಿಂಗ್ ಇಬ್ರು, ನನ್ಗೇನಾದ್ರೆ ಏನು, ಐ ಎಮ್ ನಾಟ್ ಬಾದರ್ಡ್, ನನಗಿಲ್ಲ ಅಂದ್ರೆ ಇದು ಹಿಂಗೆ ಆಗ್ಬಿಡುತ್ತೆ. ವೆರಿ ವೆರಿ ಸೀರಿಯಸ್ ಸೋಷಿಯಲ್ ಪ್ರಾಬ್ಲಮ್.
ತುಂಬಾ ಈಗೋ ಟ್ರಿಪ್ಸ್ ಬಾಳ್ ತೋತಾ ಇದೆ.
We have seen our parents, we have seen our generation, now we are seeing children generation.
Correct.
I mean, that generation requires a lot of mentoring, my lord.
In fact, there is one book written by some American, how to be a good spouse ಅಂತ. ಅದರ ಕೆಳಗಡೆ this book is not meant for Indians and Chinese ಅಂತ. But now in the next edition, what he has written, I do not know.
No, actually, whenever there is a matrimonial problem, I tell them to read the book called The Man Who Sold the Ferrari.
ಅದು ಒಂದು ಶರ್ಮಂದು, ರಾಬಿನ್ ಶರ್ಮಂದು. ಅದೊಂದು. ಇನ್ನೊಂದು ಅದು man is from Mars and woman is from Venus.
That is also.
There is one more book by Bertrand Russell, Marriage and Morals.
And
in great work.
Don't say yes when you have to say no. That's another beautiful book.
There's Eric Fromm. Eric Fromm.
Really, really wonderful book.
But ಯಾರು ಓದ್ತಾರೆ ಈಗಿನ ದಿವಸದಲ್ಲಿ? ಅಧ್ಯಯನ ಬಹಳ ಕಡಿಮೆ ಆಗಿದೆ. ಅಧ್ಯಯನ, ಅಧ್ಯಾಪನ
ಇವಾಗೆಲ್ಲ ಅಮೆಜಾನ್ ಕಿಂಡಲ್
ಮುಗೀತದೆ.
ಮಾಡೋದು
ಪಿಟಿಷನ್ಸ್ ಹಂಗೆ. ಅದ್ ನೋಡಿದ್ರೆ ಸಾಕು, ಕೆಲವು ಪಿಟಿಷನ್ಸ್ ಓದ್ಬಿಟ್ರೆ ಸ್ನಾನನೇ ಮಾಡ್ಬೇಕು. ಅಷ್ಟು ಹಾಳಾಗಿ ಡೆಪ್ತ್ ಇಲ್ಲ. ಒಳ್ಳೊಳ್ಳೆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ಸ್ ಅನ್ನು ಓದಿದ್ರೆ ಡೆಪ್ತ್ ಬರ್ತದೆ. ಯಾವ್ದೋ ಜಾಬ್ವಾಲಾ ಟೈಪ್ ಓದಿದ್ರೆ ಹೆಂಗ್ ಡೆಪ್ತ್ ಬರ್ಬೇಕು? ಮೆನಿ ಟೈಮ್ಸ್ ಐ ಟೋಲ್ಡ್ Aditya, myself, and we discuss why the going down, not only bar,
all walks of life, all walks.
ಅವ್ರಿಗೆ CPC ಗೊತ್ತಿರಲ್ಲ, CRPC ಗೊತ್ತಿರಲ್ಲ. CRPC ಬಂದಾಗೆ ನಾವು CPC CRPC ಅಂತ ಅನ್ಕೊಂಡು ಬರ್ತಾರೆ. ಇಲ್ಲಿ ಬಂದ್ಕೊಂಡು ಮತ್ತೆ ಡಬಲ್ ಅನ್ನ ಬಿದ್ದು ಮತ್ತೆ ಟೈಮ್ ತಗೊಂಡು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿ ಈ ರೀತಿ ಹೋಗ್ತಾರೆ. ಯಾವುದೇ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ಸ್ ಅನ್ನು ಕೋಟ್ ಮಾಡಲ್ಲ, ನಾವು ಹೇಳಿದ್ರು ಓದಲ್ಲ. ನಾನು ಸಾಮಾನ್ಯವಾಗಿ ಓದ್ಕೊಂಡು ಹೇಳ್ತೇವೆ, ನಾವು ನಮಗೆ ಇನ್ನೊಂದು ಬಿಸಿನೆಸ್ ಇಲ್ಲ. ಓದೋದ್ ಬಿಟ್ಕೊಂಡ್ರೆ ಏನಿರ್ತದೆ ಜಡ್ಜಿಗೆ?
Time has become a very difficult commodity for us.
We do not know how that can be.
Obliged for a patient hearing.
Sir, password is still. ಅಲ್ಲ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಈಗ ಒಂದೇ ಪಾಸ್ವರ್ಡ್.
ಹೌದಲ್ಲ ಸರ್? ಇಂಟರ್ವ್ಯೂ ಮಾಡೋ ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ ಸರ್. ಡೇಟಾ ಹೀಗೇನಾ? ಬನ್ನಿ ಸರ್, ಬನ್ನಿ ನೀವು.
ಸರ್ ನಾನು ಹೋಗ್ಲಾ? ಸರಿ.
Just a minute.
What of sir? What of sir? Sir, 32 ಏನಾದ್ರು ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ರ ಸರ್? ಪಾಸ್ವರ್ಡ್
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. 2 weeks ನೀವೇ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್, ಕೈಂಡ್ ಆಫ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಒಂದೆರಡು ಕೇಸ್ ಲಾಸ್ ನೋಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು. ಅದೇನಾದ್ರು ನಿಮ್ಗೇನಾದ್ರು ಗೊತ್ತಿದ್ಯಾ? ಕೇಸ್ ಲಾ ಹೇಳಿದ್ರು 183 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬರ್ಕೊಂಡಿಲ್ವಾ? ಗೊತ್ತಿಲ್ವಾ? ಓಕೆ. ಆಮೇಲೆ ಅವರು ಒಂದು ವೆಂಕಟಮ್ಮ ಅಂತ ಆಕೆ ಹೊರಟೇ ಬಿಟ್ರು. ನಾನು ಹೊರ್ಗಡೆ ವೇಟ್ ಮಾಡಿ ಅವ್ರದ್ದು ನಂಬರ್ ಏನಾದ್ರು ಇತ್ತ? ಹೌದಾ? ಆಮೇಲೆ ಸಾಹೇಬ್ರು ಆಮೇಲೆ ನಾವು ಹೇಳಿದ್ದು ಮಾಡಿಲ್ಲ ಅನ್ಕೋಬಾರ್ದು. ಎಲ್ಲ ಸಾಹೇಬ್ರಿಗೆ ಏನಾದ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು. ಏನು ಅಲ್ಲ, ಹಾಗಿದ್ದೆ ಹಂಗೆ ನಾ ಆಕೆಗೆ ಹೇಳಿದ್ದೀನಿ. ನಂಗೆ ಪೇಪರ್ಸ್ ಕೊಡು ಅಂದ್ರೆ ಪೇಪರ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ. ಲಿಸ್ಟ್ ತೋರಿಸ್ಬಿಟ್ಟು ನೋಡಿ ಇದ್ರೊಳಗೆ ಎಲ್ಲ ಇದೆ ಅಂತ. ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ತೋರಿಸಿ. ಅಷ್ಟೇನಾ? ಯಾವ್ದೋ 2-3 ಕೇಸ್ ಲಾ ಹೇಳಿದ್ರು ನಾನು ಅದಕ್ಕೆ
ಇದು 45 ಅರ್ಜುನ್. ಫಾರ್ಟಿ ಟೂ ಮತ್ತೆ 45 ಅರ್ಜುನ್ ಆಗಿ ಎಷ್ಟು 2 ವಾರ ಅಲ್ಲ? ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
Sir, first disposal को जो बना
ಸರ್ 23 ನಲ್ಲಿ ಇಬ್ರಿಗೂ ನಾವೇ BMTC ಅದು BBMP ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇರೋದಂತೆ.
ಸರ್ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಕಾರ್ತಿಕೇಯನ್ ಅಂತ ಮಾಡಿದ್ರಲ್ಲ, ಇಲ್ಲ ಟೇಕ್ ನೋಟಿಸ್ ಟು ಬೋತ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. 23 ಹಾ ಅಷ್ಟೇನೋಗಿ ಹೇಳ್ಬಿಡಿ ಸರ್, ಮತ್ತೆ ಸುಮ್ಮನೆ ಕಾಲ್ ನೋಡ್ರಿ. ಕಾರ್ತಿಕೇಯನ್ ಅಂದ್ರೆ ಮತ್ತೆ
ಸರ್ ಸರ್ ಅದ್ ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿದಾರಾ? ಬರೀ 1 ವೀಕ್ ಅಷ್ಟೇ ಅಲ್ವಾ ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್? ಇವಾಗ ಶಂಕರ್ ಸರ್ ನಮ್ 44 ಅನ್ಸುತ್ತೆ.
टीम चेंबर में कैसा सब सुबह में
ತಗೋಬಹುದು
ಸರ್ 41 ಸರ್ 41
ನಂಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬರುತ್ತೆ ಅವ್ರದ್ದು ಆರ್ಡರ್ಸ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಏನಿಲ್ವಲ್ಲ?
ನಾನು ಈ ಪೆಟಿಷನರ್ಗೆ ಹೇಳಾಯ್ತು, ಬಂದು ಹೇಳ್ಬೇಕಿತ್ತು ಅಷ್ಟೇ. ನಾನು ಫೋನ್ ಮಾಡಿ ತಿಳ್ಕೊಂಡೆ ಅಲ್ಲಿ. ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾವು ನೆಕ್ಸ್ಟ್ ವರ್ಷದಲ್ಲಿ ಇದ್ರೆ ಓಕೆ, ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಗಮನಕ್ಕೆ ಇರ್ಲಿ ಅಷ್ಟೇ. ನಮ್ಮಿಂದ ಆಮೇಲೆ ಅದ್ರ ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸರ್? ಸಾಹೇಬ್ರು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಪಾಸ್ ಅದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಇಟ್ಕೊಂಡಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ರದ್ದೇ ಅದು ಅವರು ಆ ಕೇಸ್ ಮೇಲೆ ಟಾಸ್ಕ್ ಫೋರ್ಸ್ ಬಗ್ಗೆ. ಈ KLGP ಇದು ಯಾವ್ದಿದೆ? ಅದು ಬಿಲ್ಡರ್ಸ್ ಇದು ತುಂಬಾ ಇದೆಯಲ್ಲ ಅಂದ್ರೆ ನಾನು ಕೊಡಿ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ. ಸೊ ಮತ್ತೆ 34 ಯಾವ ಡೇಟ್ ಕೊಟ್ರ ಅದಕ್ಕೆ ಪರ್ಟಿಕ್ಯುಲರ್? 34 ಅದೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆಗಿತ್ತಲ್ಲ. ವೆಲ್ಗ
ಪುರ್ಣಿಮನ್ ಮನೆ ಹತ್ರ ಅಲ್ವಾ ಇದ್ದಿದ್ದು? ಜ್ಞಾಪಕ ಇದೆಯಾ? ಎಲ್ಲ ಅವರು ಹೌದಾ? ಹೌದು ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡಿದ್ದೀನ ಪರವಾಗಿಲ್ಲ. ಅವ್ರು ಇವಾಗ ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಇರಲ್ಲ, ಶೀಸ್ ಇನ್ ರೈಲ್ವೇಸ್ ಅಲ್ಲ, ಎಲ್ಲ ಆಮೇಲೆ ಕಾಂಟ್ಯಾಕ್ಟೇ ಇಲ್ಲ ನಮ್ಗೆ. ಹೌದಾ? ಹೌದಾ? ಈಗ ಅಲ್ಲೇ ಇದ್ದಾರೆ ಅಥವಾ ಬೇರೆ ಇಲ್ಲ? ಏನೋ ಕೇಸ್ ಹೇಳ್ಬಿಟ್ಟಲ್ಲ, ನಿಮ್ಗೇನಾದ್ರು ಗೊತ್ತಿರುತ್ತೋ ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇಲ್ಲ, ಅವರು ಫೆಮಿಲಿಯರ್ ಇರ್ತಾರೆ, ಕೇಳಿ ನೋಡಿ.
So I am, my lord, relying heavily on that as far as the base tax is concerned. Because, my lord,
But how, without deciding that case also needs to be taken up along with this only.
which case, my lord?
The amendment where amendment is challenged. That you are banking upon a decision of the apex court.
Yes,
For deriving relief at the hands of this court.
yes.
The judgment of the apex court, you said, is nullified by the amendment.
Judgment
A
of the apex
challenge
court,
is-
my lord, judgment of the apex court. And in fact, in the explanation, when the explanation is added in 2010, that explanation to section 917, there they specifically in the language they say that to get over, because Karnataka High Court in 2009 has held that it has to be rendered and utilized. Therefore, we are now passing amending.
So that will have bearing on this also.
Well, I have two submissions here. But as far as the base tax is concerned, eventually, my lord, this is only tentative proceeding. TDS is only, my lord, tentative. I have to deduct TDS if it is chargeable to tax. If I don't deduct, there is a penalty. Penalty also, if I have reasonable cause, no penalty. That's 273B. But payee, my lord, also files. Ultimately, the money is to go to payee. Now, in the Bombay proceedings, ITAT is held in favor of the payee, saying not even 1 rupee is exigible. That matter is pending in the High Court, my lord. There is no stay of the order, but that matter is pending. 2017, question of law have been framed. Two questions of law have been framed in that appeal. One, what is the effect, if any, of the amendment on the judgment of ITAT? And two, my lord, there is a Indo-US DTA, double taxation avoidance agreement, where, my lord, actually they rely on that, the ITAT, that if your services are inextricably linked to the supply, and supply was high seas.
Very well. Which is the judgment you want to bank upon in this case?
In this case, my lord, this is 2022 3 SCC 321.
Whether amendment of the act has something to do with this judgment?
Yes, yes.
Then
Because why I am telling you, in this also it was amended retrospectively.
Correct.
And my lord, the issue was whether as far as the person who is the deductor, who is to deduct.
He could not have done it because he was not there.
That is exactly what I am saying here.
That we can understand. But when the act is challenged, who has challenged that act? Your client?
Writ petition explanation has been challenged by.
Explanation has been
Your
challenged.
client only.
Our client.
We will post that matter also along with this fixed date.
Lordship may do it. But my lord, I am on the other, that penalty issue. Because my lord, penalty is not subservient to a decision in this. Penalty proceeds on the basis that there is an exigibility. Because my lord, ITAT says there was exigibility, but under 273B, because there was reasonable cause, and they give a detailed judgment, reasonable cause, therefore no penalty. Base tax, yes, liability, but no penalty. My lord, that is a one-page appeal, one ground appeal by them. That, my lord, your lordship can decide and finish it. As far as the, because my lord, three reasons I am giving. Just, my lord, before my learned friend. One is, my lord, they themselves, according to me, were not serious about the appeal. It is just a one ground appeal, my lord, one pager appeal. They refunded immediately. But the problem today with me is this. My lord,
penalty.
If they succeed, I have to return with interest. And interest is mounting, whereas, my lord, this is a matter which will not take more than 15 minutes. In fact, there is a recent division bench judgment of this honorable court where they say that because of an inadvertence, just because there is penalty, you need not levy penalty if there is no dishonesty.
So, mens rea is a
they rely on also, my lord, Supreme Court judgment. There is, my lord, a Hindustan Steel judgment of 60s, though under Sales Tax Act, but that is cited everywhere, my lord, because penalty was there in under Sales Tax Act. There they say unless it is a malified act or a dishonest act, penalty should not be levied. Now, here in this case, my lord, we have on the record, that's what ITAT relies on. We have on the record opinion of a chartered accountant, opinion of a law firm, attempt made before the authority of advance ruling, but unfortunately no decision.
Did not decide that.
And also, my lord, an application made to the assessing officer, no objection certificate was sought for making payment with detailed representation that there is no tax. Moment, my lord, on 19 December 1997, he says, no, you have to deduct first January, 5th January of 1998, money is paid. And so those are the facts. And my lord, their one ground appeal is this. They say there was a survey done by them on 17 December of 1997. These dates are very important, my lord. 17 December, Lordship may just note. 17
Amendment Act and
Your Lordship, the problem is, my lord, first tax cases has to be decided. Penalty will follow. Both the cases are there. If I lose penalty here, because considering the tax effect, my lord, I have to take this matter to Supreme Court first. The Supreme Court, when the tax matters are still pending.
No, my lord, tax is not connected with this.
Supposing,
my lord, tomorrow, let us assume.
Tax ide. Your Lordship, today, your Lordship is dealing with two types of matters. One is tax for 2 assessment years.
There is penalty.
A penalty, my lord. Your Lordship, learned senior college.
No, what he says is,
penalty first.
even if the tax matter is lost,
yes,
still the mens rea element which should animate the tax, the penalty order, that is lacking. Therefore, that makes no difference.
Exactly.
Even otherwise, whether there was requirement for the assessee to deduct tax or not, your Lordship has to go into the merits of the case.
No, if we come to conclusion, the income was not excisable to the tax at all, then penalty proceedings will fall down on that itself. In the event we take the contra view, still what he says is, unless there is mala fide, you can't just directly go for penalty proceedings.
Correct.
Totally independent. If they succeed in appeal, the question will not arise at all. Assuming that the amount is taxable.
Yes.
Still penalty proceedings could not have been initiated.
That's exactly what. And my lord, your Lordship may just see two facts I'll just play. My lord, there is a survey on 17 December.
He has to respond to our version.
Yes,
yes.
Your Lordship, for that one also, my lord, whether prima facie, my lord, he has to show there was no liability on me. I should.
No. We'll assume that there is liability. What he says is, assume that there is liability.
Correct.
How can you take up the penalty proceedings unless it is animated with some guilty mind? Gross negligence, gross inadvertence, mala fide, malice, something like that is necessary is his contention. Assuming that he will lose that the issue as to the taxability is decided against him, still this will be red law. If taxability is decided in his favor, this will fall down as a pack of cards. So either way, it is independent.
Your Lordship, that is there. What he says is correct. But your Lordship may kindly see, considering the tax effect, what
are you going to do with that tax effect?
Your Lordship, because the penalty is held against me.
No, we will decide that taxability in your favor. How can you maintain this even then? Is his question. That we have to examine independently.
As penalty is concerned, first in penalty, what happened, my lord? In the first year, my lord, he was deducting tax. A non-resident company legal consultant told that no, this tax is not attractive. You don't deduct any tax.
Two opinions he has taken.
Yes, my lord.
One from legal firm, another is chartered accountant.
Yes, my lord.
Another is he moved application for advance ruling.
Yes,
the authority
and
did not decide at all.
And fourth, my lord, before the assessing officer, under 195, I sought a no objection with the detailed representation of the payee saying that no taxability.
Suppose if advance, one second.
Yes.
If advance ruling is sought for,
yes,
and it is not decided in time, what is the consequence? Under our law, the state law, if it is not decided in a particular way, the presumption is that what he has sought for is in his favor. Is there such a provision in Income Tax Act?
No.
The provision doesn't say it, but Lord, that will show that there was no malafide in my mind.
That we'll consider. That's another.
Yes. 245Q, my lord, just gives a right to the payee, that is Riol in this case, because Riol had moved, my lord, the authority on advance ruling.
And anyway, the taxability is on the person who should pay.
That matter is
not on the person who effects TDS.
But he has to deduct TDS, not.
That's all.
That matter is pending before Bombay High Court, whether he is liable to pay or not, that non-resident company.
No, why we should wait for Bombay? If we decide Bombay may follow us.
Your Lordship may can first hear the tax appeal, not.
Why anta?
That requires.
Why it should be, assuming that it is decided in your favor,
Yes, my lord.
still this remains as it is. If that is decided against you, nothing will remain in this. This is what learned senior advocate is saying. May I know your name, sir? Sorry.
Sohail Dutt, my lord. Sohail Dutt. Sohail Dutt. S. Dutt. Sohail Dutt, my lord.
Sohail Dutt.
Your lordship, since both the matters are posted, I am ready to argue both the tax appeal as well as penalty. Both matters I am ready, my lord.
Suppose if we agree to his proposal, is there any action being taken against you, your interim order?
No, my lord, there is no action. As far as, my lord, the base tax is concerned, money came to them in 98 itself. Money is with them. Because as I said, my lord, moment in my 195(2) application, he said, assessing officer said you have to deduct. Immediately, my lord, payment was deposited.
You want preparation for this case or you want
Both
that?
the cases I am ready, my lord.
In this case,
Your lordship.
then you argue this.
Yes, my lord.
Whatever happens, happens.
It's one page appeal, my lord.
Where is that?
Yes.
Which is the section which we have to read?
271C and 273B.
How that is constituted as requiring?
271C says someone who has to deduct doesn't deduct penalty. 273B says no penalty if reasonable cause. So they have to be read together.
In the first one, there is no reasonable cause concept at all.
But 273B is very clear that
Reasonable clause can be shown.
if reasonable cause, then no penalty.
Your case is that the reasonable cause is
There is
shown.
reasonable. That's
That
what
need
ITAT
not
has held.
interest the ITAT.
And my lord, ITAT is, that's a matter of fact.
Let us
So
see.
there is no substantial question
Understood.
of law here.
Understood. Good. (271)
C and 273B, my lord.
271C. And 273B.
B.
Capital B.
Capital B. 271 capital C, my lord.
Kindly read slowly. We are little slow because we
Yes,
do not
yes.
belong to this domain of law. Yes. If any
Person fails to deduct the whole or any part of the tax as required by or under provisions of chapter.
This is TDS.
Yes, my lord.
Pay or the whole of
Then, my lord, B, pay the whole or any part. Then, my lord, then such person shall be liable to pay by way of penalty a sum equal to the amount of tax which such person failed to deduct or pay as aforesaid. Any penalty imposable shall be imposed by the joint commissioner.
In your case, joint commissioner imposed it.
Yes, yes.
Okay.
He imposed 100%, my lord. So whatever was the base tax amount, and then your lordship may see 273B. Notwithstanding, my lord, non-obstante clause, notwithstanding, it is 273B, my lord. Capital B.
B. You're right.
Notwithstanding anything contained in the provisions of clause B of subsection 1 of section 271.
271, which non-obstante is to
Yes.
what?
Notwithstanding anything contained in the provisions of clause B of 271, 271A, 271AA,
C is also
271C,
included.
and also the next page, my lord, 271C also is mentioned.
Correct.
Etc.
No penalty shall be imposable.
Shall be imposable as the case may be referred to if he proves that there was a reasonable cause for the said failure.
That's
Now,
all.
That's all. So if there is reasonable cause, no penalty.
No, what you say, the 3 exercises which you have already taken.
4 exercises.
4 exercises amount to reasonable.
Amount to reasonable
So
cause.
that exercise was undertaken.
Yes, my lord. That is mentioned in the impugned order itself. So lordship has the penalty paper book, my lord.
Page number? 3025, 2005, this original the petition.
That is in
appeal.
respect of tax, my lord. Your lordship may kindly have 1186 for penalty cases.
1184 and 1186.
ಇದು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ.
ಇದು ಈ ಪೋಸ್ಟ್ ಆಗಿದೆ ಇದು ಟ್ಯಾಕ್ಸ್ ಬಗ್ಗೆ ಇದು.
Tax, will you hear that separate?
Yes, my lord. Penalty ತಗೋಬಹುದು.
This is 3022.
No, 1184, sir. Your Lordship's
1184.
1184 and 1186 of 2006, 1184 of 2006.
Why?
But Mr. Dutt, whether certain acts amount to sufficient cause or not,
Reasonable cause, yes.
reasonable cause or not, the apex court said is not a substantial question of law.
Correct.
Then
Exactly.
how appeal is maintainable?
That's my first point, my Lord. It is a finding of, because, my Lord, your Lordship knows, tribunal is the last, my Lord, the forum, as far as
For appeal.
Yes, my Lord.
Is
Can I
there
clear
appeal?
my appeals?
is their appeal.
Then you should allow him to argue.
Yes, yes, let him out. I have no difficulty.
Your Lordship, I will just bring out the facts of this case, my Lord. The SSC is the Indian company, my Lord. They wanted to put up one plant in Ballari, in Thorangal, my Lord, one power plant. For that one, my Lord, they entrusted 4 types of work to 4 companies, my Lord. One is non-resident company, my Lord, Riol. One is non-resident company. Other 3 companies are Indian companies. As far as non-resident companies concerned, my Lord.
Now, we will assume now
Yes, my Lord.
that he was liable to deduct the tax.
In respect of non-resident company.
Correct.
Non-resident company.
We'll say that he is liable to deduct.
Yes, my Lord. Your Lordship, in respect of non-resident company, 2 types of works were entrusted. One
Why
is,
all that? We
No.
are in full agreement
Lordship-
with you that tax was deductible,
yes, my Lord.
subject to outcome of this accompanying appeal.
Yes, my Lord.
Now
Lordship-
you answer the question,
Yes, my Lord.
whether certain acts amount to reasonable cause or not
Yes, my Lord.
is not not a question of law at all.
Yes, my Lord.
How
Your Lordship,
appeal is
only on the
maintainable?
ground of perversity I can challenge, my Lord. If the tribunal's order is perverse or any evidence has been ignored by tribunal.
Which evidence is ignored by the tribunal?
Your Lordship, the findings of the penalty order, my Lord, by the assessing authority has been ignored by tribunal. That is my submission.
Which
my
one?
Lord. The findings rendered by the assessing officer in penalty order
About
about the deduction of tax.
who
The
passes the penalty order?
the assessing
Commissioner,
officer.
joint commissioner
No, my
passes
Lord.
that
The
order.
first stage is penalty assessing officer, my Lord. Against this order, it goes to first applied authority, my Lord, Commissioner of Income Tax. Again to the tribunal. My Lord, tribunal has held against me, my Lord. I have come before this honorable court.
Correct.
The
How
substantial,
section reads substantial question of law is
yes, my Lord, 260A, my Lord.
is it defined?
Your Lordship, it is not defined, my Lord.
Not defined.
Your
Any
Lordship,
judgment
the-
support
Your Lordship,
for
in
contention?
the case of Vijay Kumar Talwar, my Lord, the Honorable Supreme Court has held, my Lord, the substantial question of law rises when the tribunal's order, number 1, if it is perverse. If the tribunal has ignored any.
So that will
material-
not apply to this. There is no perversity.
Your Lordship, the questions of law.
Two might have questioned, 100
one-
odd questions.
just-
Where is the perversity?
You-
Perversity ಅಂದ್ರೆ ಏನ್ ಗೊತ್ತಾ? Saying something contrary to evidence is perversity.
I have not even raised that, my Lord.
Ah.
Just read the question, my Lord.
All right.
So, Lordship, whether the tribunal was correct in holding that the assessor's short deduction of TDS and belated transfer of TDS amount deducted to the department was due to reasonable cause and penalty and could not be levied without taking into account that all this clarification regarding legal position was taken by the assessee due to survey conducted by the department pursuant to which the defect was pointed out and consequently the penalty levied under section 271C of the act by the assessing officer was justified. This is the only question raised.
Correct.
Here I have not raised about perversity or ignorance of any material.
What is ignored is also not there. How this amounts to substantial question?
That one
Question of law, substantial ಹೋಗ್ಲಿ.
it's a factual fact.
Pure question of fact ಆಗ್ತದೆ.
Yes, my Lord. Even otherwise, my Lord,
Even mixed question of law and facts ಬರಲ್ಲ.
ಇಲ್ಲ ಬರಲ್ಲ.
Substantial question of law on par with section 100 ಅಂತ we have held that way. It is affirmed by the
Yes,
Supreme
Lord.
Court now.
Only on fact, what I have said in the substantial question of law is that only after survey means under section 133A, we go to his premises and notice all these discrepancies that he has not detected TDS.
That is a
Non-resident company has not detected TDS. That survey, when we had gone there, it was noticed and it was brought to his notice. After that survey only, he started deducting tax and remitted it. Therefore, he he committed a mistake intentionally.
Where have you stated?
The substantial question of law, my lord, the conduct of the assessee, my lord, shows
Where
that.
have you said word, used the word intentionally or guilty mind?
ಇಲ್ಲ, ಅದನ್ನ
Appeal is not maintained.
ಇದರೊಂದು ಶಾರ್ಟ್ ಆಗಿ ಒಂದು ಇದನ್ನ ಹಾಕಿದ್ದೀನಿ 2 ಪೇಜ್ ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ಸ್ ಅಂತ.
This appeal by the revenue seeks to call in question the order dated ಏನದು?
Your Lordship,
4/5/2006, whereby the Income Tax Appellate Tribunal Bangalore has negatived revenues appeal in ITA number 100/Bang/1999, wherein the order of Joint Commissioner, another, whose order was challenged in the appeal?
In the first appeal, my lord.
Order of CIT, Proceedings Appeals, -4, dated 20 January 1999 for the assessment years 1996-97 and 1997-98, by which penalty levied under section 271C of the IT Act 1961 was confirmed. Correct?
Yes, ma'am.
Was confirmed. First off, ಕೂತ್ಕೊಳ್ಳಿ. The a coordinate bench of order ಕೊಡಿ. A coordinate bench of this court, wide order dated order sheet.
Your Lordship, penalty appeals, there is no review petition, my lord. It is fresh, my lord. Only in respect of tax cases, my lord, it is disposed of and we approach the Supreme Court. After SLP, we file review petition. As far as penalty, it is not there. It is a fresh case.
Fresh case, but admit ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಮತ್ತೆ ನೋಡೋಕಲ್ಲ ಯಾವ ಕ್ವಶನ್ ಮೇಲೆ admit ಮಾಡ್ತಾರೆ. ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ?
Your Lordship, in 2006, my lord, I am sorry.
ಅಲ್ಲ ಅದು ನೋಡೋಣ.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಮಿಕ್ಸ್ ಆಗಿರ್ಬೇಕು ಬೇರೆ ಕೇಸಲ್ಲಿ.
Order is blood July 27, 2007.
First, a coordinate bench of this court, after hearing the learned panel counsel appearing for the revenue, had wide order dated 27/7/2007, having accepted the version of the revenue, had admitted this appeal on the following question, substantial question of law. First, next paragraph. After service of notice, the assessee having entered appearance through its counsel vehemently resist the appeal. ಇದು ರಿಮೈಂಡ್ ಆಗಿ ಬಂತಾನೆ ಇದು?
ಇಲ್ಲ, ಇದಿಲ್ಲ.
ಇಲ್ಲ,
ಓನ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಮಾತ್ರ.
Okay. Resist the appeal. Firstly, contending that the question on the basis of which appeal is admitted at the instance of the revenue does not partake the character of question of law and much less the substantial question of law. semicolon. Secondly, there is abundant evidentiary material which vouched the version of the assessee as to the reasonable cause for not effecting TDS, semicolon. This aspect having been duly considered by the ITAT, comma, even on fact matrix, the interference of this code is not warranted. Argued learned senior advocate Mr. Dutt, appearing for the counsel representing the assessee on record. First up. Next one. Having heard learned panel counsel appearing for the revenue and having perused the appeal papers, we are broadly in agreement with the submission advanced on behalf of the assessee that the question on the basis of which appeal has been admitted does not have the elements of questions of law, much less substantial question of law. First up, summoned in his jurisprudence 12th edition, Fitzgerald says that ordinarily a question that can be answered by turning the pages of the statute book partakes the character of question of law, semicolon. There are many exceptions recognized by Indian judiciary to this general proposition, comma, is also true. First, however, the question as to reasonable cause as enacted in section 273C
B.
273B of the 1961 Act is a mixed question of law and facts, comma, if not a pure question of fact. First off, such questions do not give right of appeal at all. First off, it hardly needs to be stated that the idea of substantial question of law enacted in section 260,
271C.
271,
271C.
question of law,
260A, Lord.
260 capital A part is approximated to section 100 of CPC by a coordinate bench of this court in the light of apex court decisions. First, next paragraph. The second contention of the learned panel counsel that where there is perversity or that the competent authority or tribunal ignores a relevant piece of evidence, comma, even such circumstances are treated as fitting into the cases of substantial questions of law may be true. First off, however, such a contention does not avail to the revenue in as much as the same has the question based on which the appeal is admitted does not get into even its penumbra. First off, such a contention is not taken up in the appeal memo as fairly conceded by learned panel counsel.
That's it.
That last bit considered by all right. Next paragraph. Learned senior advocate Mr. Dutt is right in notifying to the court that that his client had obtained a legal opinion dated
30th May 1997, my lord.
sit down and answer.
30th May
Dated
1997 from
30
law firm.
5/1997 at the hands of
Law firm in Delhi, my lord, Messrs. Singhania and Company.
Messrs. Singhania and Company, a reputed, a law firm of repute, semicolon, the legal opinion of chartered accountant.
Chartered accountant, my lord, oral opinion of Lovelock Lewis.
The opinion of
Chartered accountant, Lovelock Lewis.
chartered accountant firm.
Lovelock Lewis. I'll give LOVE LOCK Lewis LEWI.
Yes.
I'll write them. I'll write.
Signed, so.
लिख के दो.
And another is.
And then not moved the payee, that is Riol, had moved an application under
Advance ruling.
Advance ruling on 11th September 1997.
Semicolon. This apart, an advance ruling was sought for at the hands of the commissioner.
At the hands of the payee Riol, the party who ultimately who got the money. To whom the money is paid by us. Riol.
At the hands of
the payee. Yes.
Payee. Wide application dated
11th September 1997, my lord.
11/9/1997.
And on 30th September, the learned chairman said because of difficulty.
However, the
said application was not heard.
application was not processed for reasons best known to the revenue itself.
For the reason, personal reasons of the chairman of the authority. Personal reasons of the chairman of the authority.
The personal reason
of the chairman of the
authority. First off, these circumstances repel the contention that there is any guilty mind with the respondent herein in not effecting the deduction. First off, first paragraph. The vehement submission of learned panel counsel appearing for the revenue that this matter be taken up along with the taxability matter in ITA number
3022.
3022 and 23.
22 and 3023 of 2005 that are remanded by the apex court, correct?
Yes,
that are
not
remanded
that are filed in view of the decision of the Honorable Supreme Court.
That are filed in view of decision of the
the order of the Supreme Court.
Yeah, order 2022.
Your Lordship, the Supreme Court ordered
Order 2022. First off. However,
order is
we did not agree with this proposal since we cottoned with the submission of Mr. Dutt to the effect that even if those appeals are decided against the assessee, still this case would stand as an island case. First. Therefore, we have taken up this matter for final this long pending matter for final disposal in the first paragraph. Madi, just only refer to text of section 271C and 273B. Any decision which says about this, any decision of
two decisions, Lord. One, Delhi High Court, which says that yes, that is Itochu Corporation. Last paragraph, that decision whether it's reasonable cause is a matter of fact and there is no substantial question of law.
Same is held.
Yes, para 7, my lord.
Does not amount to question of substantial question of law.
Lordship,
this accords with
the view of division bench of my lord Delhi High Court.
Division bench of Delhi High Court decision.
Para 7, my lord.
Of Delhi High Court.
Para 7, last para, my lord, if your lordship sees.
2004.
और वो दूसरी
75 DRJ
अरे एक ये भी
337 DB paragraph 7.
last para, my lords, para 7.
The division bench again reiterated.
There, it says, in view of what is stated, we are of the view where there is a reasonable cause or not is a question of fact which has been determined by the tribunal. As such, no substantial question of law arises.
I felt like that. In fact, I had not seen this judgment.
Yes. ये वाली.
Para 7 reads as another judgment.
Here, my lord, they say it is a finding of fact and it is not perverse. Here in our case, my lord, they have considered it perversity.
Do this.
Yes. This part, last, is the one I have ticked. The one I have ticked.
In fact, on the CPC, sufficient cause mele, there are decisions holding that whether it's a sufficient cause or not is not a question of law.
The one that I marked, my lord, tick mark.
Correct. ಇನ್ನೊಂದು ಬರ್ಕೋಬೇಕು. Madras High Court DB judgment. Paragraph last part of 8. In the matter. All right. In the above circumstances, this appeal is liable to be and accordingly negative. Costs having been made easy.
Separate order for two appeals.
ಎರಡು appeals ಇದೆ
1184
separate.
and
1186.
The subject matter of this appeal is substantially similar to the one in ITA number so and so,
1186.
which we have disposed of this day. This day. First off, it hardly needs to be stated that similar cases should be treated, like cases should be treated alike, and therefore, whatever order has been made in the cognate case needs to be printed in this appeal as well. First, in the above circumstances, appeal is dismissed. Courts having been made is. Thank you. Thank you, Mr. Dutt. We made you wait.
No, no, my lord, I am grateful. We learn, my lord, every day from the bench. This Salmon, my lord, what your lordship has quoted here is something we had read, my lord, Salmon in law faculty, but we had all forgotten.
No, Salmon's
this on this question of law, my lord.
10th,
What your lordship just dictated.
7th edition.
Yes.
7th edition. By
We learn, my lord, from the.
No, we also learn from you. That's another thing. He discusses four things: question of law, question of fact, question of opinion, question of discretion. Question of law.
Which edition, sir?
7th edition by Glanville Williams.
I see.
Even in Fitzgerald's 12th edition, it is repeated. But
Grateful.
Glanville Williams had treated it very beautifully. Glanville Williams was King's Counsel. He
yes,
wrote
yes, yes.
silk
Yes.
like you. Yeah. He has said, which is question of fact. Anything that is to be answered by looking to the record of the case on evidence is a question of fact. Any question which is to be answered by turning the pages of the law book is a question of law and subject to exceptions, etc. Anything about opinion, whether, for example, question of fact, whether Alexander had come to India in BC 323. It's a question of fact that he had come because evidence can be laid.
Correct.
He fought that war, Ambi was defeated, this, that, etc. Whether a person like Alexander would come in the year 2030 is a question of opinion. Till that happens, we do not.
We do not.
Then question of discretion, 5 years imprisonment or 7 years imprisonment.
Discretion.
Discretion. These are the only 4 questions that would appear before the courts. No other question. And their Permutation combination.
Correct.
That's what.
Yes.
That is, Mr. Dutt is from which place?
Delhi.
Delhi. Are you going back today?
Yes.
Then post this appeal. When shall we fix this matter?
Date in March, if it is convenient.
My submission is that, my lord, if they are going to argue the writ petition validity of that explanation, my lord, let it be deferred, my lord, because let the Bombay High
We'll
Court.
call that also.
Your Lordship, if that.
Why Bombay? This
question
is
of-
also High Court. Why we should
Your
wait?
Lordship, if it is only question of tax, my lord, involved, tax appeal is there in Bombay.
Taxability.
But here it is validity, my lord, it is.
We will consider validity only. Why we should not consider? Do you think that we are inferior?
No, my lord, it's not like that. The question of arguing that it will be.
No, if we consider validity, constitutional validity of taxation law, we are not very good in taxation, is true.
It will take some
But
time.
we can be made good by your assistance.
No, my lord, because it will take time, my lord, because for arguing the validity matter, my lord, I have to.
Which year matter?
That is 2011.
11.
2011.
Writ petition of 2011.
14 years are over.
Because your Lordship, even after.
You tell whichever date you want.
Your Lordship, one submission, my lord, without going into that aspect, my lord, before, after, there is latest judgment of Supreme Court, my lord, in favor of the revenue, that covers the issue itself, my lord, DVK Industries. Without going to
We
the
need
question
not
of.
go to validity at all.
Yes, my lord, that's not at all required if I succeed by relying upon the judgment. In fact, by relying upon the judgment, only review petitions were allowed and matters were restored, my lord.
1 second. Whether the apex court considered that act also?
That is taken note of, my lord.
That is taken note of.
Yes, my lord. Without going into the amendment in explanations, my lord, the charging provisions itself provide that TDS is liable to be deducted.
1 second. If amendment is struck down, what is the effect on your appeal?
You will should dehorse that amendment, my lord.
Also you're entitled.
Yes, my lord.
Okay. So it has nothing to do.
Yes, my lord.
Then why that act is challenged?
Lord, act is challenged because, Lord, we are saying that to get over a judgment, you are doing a retrospective amendment. The only purpose is, because I will show from the explanation, and there are judgments, my lord, there is law. There is law on both sides, my lord. Ultimately, your lordship will have to decide. There is a law that once legislature has the competence, then, my lord, then they can do retrospective. But there is also law, my lord, and there is Supreme Court judgments.
Too much retrospectivity is unreasonable.
Is unreasonable. 1, 2, to get over a judgment, if it is only to get over a judgment, then that is also, my lord, there is a Supreme Court judgment. That is also arbitrary, unreasonable.
Well, Ashok,
That
what happened in this case, my lord? This honorable court held that the TDS is not liable to be detected if services are rendered abroad. And
That is reversed by law.
yes, my lord. By the amendment and in the object, we have quoted that judgment itself, my lord. And the matters were pending in Supreme Court. The Honorable Supreme Court observed that since you have amended, there is explanation, you go back and file review petition. Without going into that amendment itself.
But there is
my lord,
also, my lord, this judgment of 2022, Justice Nariman's judgment for retrospective amendment may have, maybe the pay may be liable if it is retrospective and if it is not arbitrary, unconstitutional.
Not TDS fellow.
Not the TDS person, because you are not supposed to do an impossible, which was not there in the statute book. That's the judgment, my lord. So we will rely on that, because as far as, my lord, whether pay is liable or not, real, that will be decided by the Bombay High Court. ITAT as of now has decided in favor of the pay.
And you could not have deducted at all is your question.
Yes.
So impossibility.
Impossibility, that's not what has been held by the Supreme Court. And in GVK's 2015 judgment, they don't go into this issue of impossibility at all. And this judgment is not recent judgment. And in respect of, my lord, 9-1, there was an amendment in, as I said, in 2012 to royalty. This, my lord, 917C is relating to technical fees. 916 of the is relating to royalty. So royalty, there was an amendment in 2012, retrospective again from June 1976, just like our case, 2010 from June 1976. Supreme Court says that as far as the deductor is concerned, impossibility. Therefore, and relying on a Bombay High Court judgment, my lord.
Why that's the impossibility is treated.
And, my lord,
as
various
compliance.
judgments are cited. Lordship knows the principle.
So whatever date. All right. And the other one date, whichever date you want, we'll fix. And the other date,
Any day, March any day.
March,
Which-
31st March. is okay?
31st March. Before other bench. Arguably perhaps, yes. Call this matter on 31st March.
Great.
Holiday, or any other day. April first week. Fool's Day. We'll have the matter on Fool's Day. At times, law fools citizens. All right.
Great.
Along with that,
Your Lordship, let it be.
why you want to keep
Your
it
Lordship,
pending?
Because Your Lordship may kindly say, if I succeed on the GVK Industries, not, that's the end of the matter.
That treatment
If
can
they,
be
if they succeed on the explanation, my lord, what they are relying upon.
No, why you want that matter to be kept on pending for what a
Your
century?
Lordship, that question will not arise if they succeed.
Then we will dismiss that petition.
Our petitioner.
Other we will dismiss that. Why you want to keep it pending? I do not
No,
understand.
my lord, if I want to argue that, my lord, validity issue, I have to engage ASG, my lord. Your Lordship, without going to that validity aspect, my lord, if I succeed on the ground.
Understand your logic at all.
Your Lordship,
Generally, it's very substandard submission.
Your
Really,
no, my lord,
constitutional validity is being challenged.
that
And
question,
it is pending since how long?
Your Lordship,
11 years.
that question need not be gone into, my lord.
Then
That
you
is
will dismiss that petition. If we agree with that view. You're avoiding argument. Why we don't understand that? Somebody has to argue that you want to keep that matter pending throughout as a court of record. It should.
No, but after disposal of these cases, my lord, it will not.
Then we'll dismiss that. What kind of, we do not understand the logic at all.
In fact, my lord, if it is held in their favor, then that will be very relevant. If supposing, my lord, your lordship comes to the conclusion that it is exigible, and then that exigibility is based on the amendment only.
I mean, that is based upon, the accessibility is based upon the act, even independently that it is possible.
Yes, my lord.
Then we'll dismiss that petition if we agree with you. Why are you afraid to argue?
Because it will take some time to get
It
ready
should
for
take
that.
time.
I have
11
to-
years are over. 11 ವರ್ಷ ಆಗಿದೆ. Validity of legislation 11 ವರ್ಷ ಆದ್ರೆ ಇತಿಹಾಸದಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀಯಾ? ಮುಂದೆ ಒಂದಿದೆ. ಯಾವುದು ದಟ್ Coelho, IR Coelho. That's the only case where they have kept it for decades. We will not keep it. 11 years agide petition. How long you want to keep it pending? You know, revenue should not think somehow I should get the order in favor of the government. You are not the mouthpiece of government. You are mouthpiece of legislature. Not government at all. ಏನಿದೆ ಅದನ್ನ ಮಾಡ್ಬೇಕಪ್ಪ ಬಿಡ್ಬೇಕು. We'll whichever date in April ನಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. Whichever date you want. ಹಾಕೊಳ್ಳಿ. Whichever bench will come, it should hear the matter. You can't keep it pending like that endlessly. All right, thank you so much.
Great.
Okay.
What date?
First April. First April, I have to check.
Sir, lovely, say that, sir. Love, what is that? That lovely clue is that.
Okay. You have written that one? Second, you have written this one. Who 31st? ले लो यार. First, there is problem. First, there is a problem.
No, he has given the date, sir. Yes, sir, please. L O V E and how to write it? L
Third ले लो. 3rd April. 3rd April.
Love lock. LOCK space LEWIS. WIS. I will. This is one word.
This is another word. Sir, love. No.